right, all. Thank you so much. I see that it is 10 o'clock here, so I want to give us basically the time we need to start. So I think as folks are trickling in, thank you very much for coming today. We're going to just be getting started in with our tenant landlord law overview. This will be a well, 4.5, but our CLE. We will have a break for lunch around noon. And so we'll be going through several different several different speakers and panelists. We'll get into that a little bit more. We have applied for 4 CLE credits for today. I have not heard back of whether we've been approved or not. I've already sent in that paperwork, so that's in the hands of the CLE folks now, but we will certainly send out that code as soon as we get it. I apologize that I can't put it in the chat or anything right now. I just don't have that information yet. All right, so we're going to go ahead and get started. My name is Rachel. I'm with Homeline. And just as a quick overview, what is Homeline? So Homeline is a nonprofit that helps Minnesota tenants across the state navigate what their rights are under Minnesota tenant landlord law. This is our phone number. It's a toll-free hotline. We also offer our services in Spanish, Somali, Hmong, and um, English. And then we also have an online email option. All right. Homeline, like I said, is a statewide nonprofit. At this point, we've advised over 341,000 renter households. So we have a lot of experience here. Today's speakers, again, there'll be several of them, bring over 87 years of experience combined with this area of the law. And we as a group of today's speakers have advised over 122,000 renter households ourselves. So at this point, we've been through a lot. And so we are hoping that, that experience carries through with what we're presenting today. Couple of housekeeping notes. This session, as you heard, is being recorded. If you have questions, we do encourage questions. We will be covering a lot of territory today, so hopefully the questions that you have are going to be covered in the extant slides, but if something comes up that you've got questions about, we will put them in the Q&A and we'll do our best to get to them. I'm confident that we probably won't be able to get to everything because I do have a schedule to keep to make sure that we are getting through all of the material that we have promised you. And so, but if you do have questions, please put them in the Q&A function. That's going to be, if you don't have it immediately in your bottom of your Zoom screen, if you go to the More section, the little circle with 3 dots in it, you should be able to find the Q&A button there, and you can open up and put your questions in there. Again, like I said, we are applying or have applied for 4 CLE credits, standard CLE credits for this today, and we will let you know as soon as we find out what that code is and if we've been approved for all 4 of those credits. So, and thank you for joining us. So this is part of our agenda. As you can see, quite a few things that we'll be covering, but also there's a second page to this agenda with even more stuff on it. So this is what's going to be in our afternoon session. So to scroll back quick, this is our morning session. These are all the things that we'll be covering between now and noon. And then this will be what's covered in our afternoon session. All right. So without further ado, let's get started. All right. So a couple things just to lay some groundwork, lay some baselines. What is a tenant? So we talk about tenant landlord law. So what do those terms actually mean? So a residential tenant is a person who occupies a dwelling, whether through a written lease or an oral lease, but basically is exchanging money or services for the uh, right to be there, the right of possession. A residential tenant can also be any other regular occupant of that dwelling unit or a resident of a manufactured home park. A landlord is the owner of the real property. So that is the actual property, and it can be a person or it can be an entity. Also can be the entity's agents or the person's agents as well. So things like property managers are often construed, acting on behalf of landlords, and so they also have some of that authority. All right. And you'll see at the bottom of the slides here, the statutes that kind of where we're pulling this information from. We're not going to necessarily cite all of the statutes verbally, while we're talking about this, but that information is going to be at the bottom of the slide where we're getting our stuff from. All right, so there are many types of tenancies, right? So again, we're going to be talking about residential tenancies, not commercial tenancies. Commercial tenancies are businesses and they also are often renters, and some of the rules that we're talking about also apply to those tenancies, but again, we're focusing on residential tenancies. So the types of housing that often are residential tenancies are going to be like private housing. That's going to be, houses or the a duplex, triplex, what have you. Um, and so often those are going to have a lease with an end date, that's a term lease, or leases without an end date, that's going to be what's called a tenancy at will. So both are fine, and that can be done through usually a written lease. We'll get into leases a little bit later. There's also subsidized housing. So that is housing that is where the rent or maybe the taxes or some part of that housing is subsidized through a another entity, usually the government. So public housing, that could be usually that's federally based, but there's also project-based housing, which is similar. Um, Other housing, hotels can be residential tenancies. They don't automatically fall into that category, but they can shift into that. So where the line is between when a person is just staying at a hotel for, a vacation or something like that to when is someone becoming a residential tenant at a hotel, there is no bright line. And so it depends on the circumstances, right? But it can become a residential tenancy. Manufactured homes as well are tenancies, even though oftentimes the manufactured homes, the people living there own the home, but they rent the lot. And so there is a whole other chapter of law that also applies to manufactured home parks, but because they are residents who are renting a portion of where they are living, Chapter 504B of Minnesota statute is going to apply to those residencies as well. All right. So yes, you will get a copy of the presentation and educational materials after we are done. I will send out those PDFs. I saw we had a question in the Q&A if we're going to get copies of the presentations and educational materials, and yes, absolutely, those will be made available. All right, so types of tenancies, I talked about tenancy at will versus a periodic tenancy or a term tenancy. So a tenancy at will, that's just one that has no set end date. So you agree, all right, we're going to usually, exchange of services or something like that for, however long is necessary. Or sometimes it's just agree to pay X number of dollars per month or per week or, whatever your term is, but there's no specific, you have a year-long lease. If you are signing like a 12-month lease, which is the most common sort of periodic or term lease, then that's going to have a specific end date for that particular contract. So that can become a tenancy at will, though. So oftentimes these periodic tenancies, after the first year, they will switch over to a tenancy at will, where the lease itself, the periodic lease, the terms of it are still fine, they're good. It's just that the tenant and the landlord, the parties, are treating it as if it's renewing on a usually monthly basis, but per rental period basis. So, but that doesn't always happen. It depends. It's on the language, right? Um, we'll get into more of that later on. So, governance, what laws impact Minnesota tenant landlord law? So obviously there's federal laws, the Fair Housing Act, HUD guidelines, all of those can impact both private and public housing. State guidelines, so Minnesota Chapter 504B, like I said, as well as Minnesota Statute Chapter 327C. 327C is the chapter of law that is specifically for manufactured home park. And then there's also local and municipal laws. So oftentimes, like for example, a city will require a rental license if you're going to be a landlord in that city. Not every city requires that. That is up to them. There is no statewide requirement for a landlord to have a rental license, but oftentimes a city is going to have that requirement. And so you need to register yourself. Usually that involves some sort of inspection requirement or at least a fee and registration that you are a landlord and that you are renting out either a portion or all of your home. There's usually a crime-free lease addendum from some cities where the landlord is agreeing to not allow criminal activity to happen on their spaces. And there may also be, depending on where you're at, like zoning, conversion fees. You know, if your space is not zoned for that sort of rental, you know, you may need to adjust that. Again, it really depends on where you're at and what the rules are in that locale. So it always is good to, you know, do your homework about figuring out what is it that you're going to be on the hook for if you are becoming a landlord. And as a tenant, all of these things as well, like there's also often, you know, the rights and the responsibilities that tenants have are also going to be outlined in these rules. All right. Um, so city rules and local ordinances. So for example, you know, I've kind of talked about some of them. So common types, you know, we already went over those, but there's also rules about like pre-eviction notices. That's a newer one, but it's something that it is definitely impactful. So Minneapolis, St. Louis Park, and Brickell Center all have additional requirements for pre-eviction filing notices. We will be getting to those in more detail this afternoon. So I'm not going to get too far into those now. St. Paul, for example, has rent stabilization ordinance where it is limiting the amount of rent increases that a landlord can make in a calendar year. Minneapolis has very specific screening criteria that a landlord has to follow and restrictions on what they can and cannot deny a tenant for. We'll be getting into more screening stuff later on as well. And then something called just cause protection. So just cause is a term where a landlord has to have a reason, a justifiable reason why they are ending a tenancy, basically. And Brooklyn Center has enacted a just cause. There are other cities that are kind of in the works of doing that, potentially. They're talking about it. But right now, at the time of recording, Brooklyn Center is the one who has that already on their books. I think there's a bunch of stuff that's going on. I think there's like St. Paul has a city council meeting today about some other tenant rights things that are coming in. So there's cities are always changing. So whatever city your rental is in, that is where you're going to need to look to for what your rules and ordinances are. All right, manufactured home and mobile home parks. So, like I said, tenants own the home, rent the lot. There are additional protections in place for these types of renters. So, application process when you are applying to be a resident there is more protective for prospective buyers of the mobile homes. The security deposit has a cap on it. This is statewide. Rent is only allowed to be increased twice in a 12-month period. So that is much different, obviously, than a, you know, say like a tenancy at will, where there is no restrictions except for in St. Paul on rent increases. Notice and a right to cure before eviction. So that's a big one where the tenant, if something is wrong and the landlord is starting to file an eviction, for something, then the tenant has the right to fix that problem before they can be evicted. It's also an endless lease, so that's unique as well, is that the landlords or the park owners can't just say, we don't want you to live here anymore. We're not renewing your lease. They can't do that. Like this, again, this is someone's home, they own that, you know, so it's a different aspect than a more traditional you know, apartment building. Um, so they also um, have a the redemption aspect of a manufactured home park is also similar to what we'll be getting into again later on for eviction actions, but redemption is the right that some residential tenants have to effectively redeem their tenancy if there's unpaid rent issue. All right, last slide for me, renters credits. All right, so ooh, we are trucking along. Perfect. So renter's credit. So that is a term for a credit that is the tenants' right, they may qualify for that. There's been some changes to it in the last year, but basically it's a tax credit that is filed with the regular income tax filings. And it is something where property owners will sometimes, will get a property tax refund, but for renters, since they're also paying part of that property tax, the renter's credit gives them a portion of that property tax refund as well. It makes them eligible for that. Now, not everyone is qualifies for getting that renter's tax refund, but that is something that certainly encouraged to apply for. Now, landlords have an obligation, regardless of whether, they qualify for a renter's refund or not. Every landlord in the state has an obligation to send out what is called a certificate of rent paid to each of their tenants, for detailing the amount of rent that their tenants paid in the previous calendar year. So a landlord has to issue that to the tenant by January 31st of every year, just like, like a W-2 or anything like that. And so um, if, say, a tenant moves midway through a year, then they should get, two um, CRPs is what we call them, from each of their landlords. Or if, even if ownership changes or something like that, there's still an obligation to send out this CRP. So even if you like sell your property, you may not necessarily be off the hook yet for everything. You got to make sure that the tenants can get that CRP and that it's got accurate numbers on it. Tenants, if a landlord does not provide a CRP by February 1st, you can file what's called a rent paid affidavit from the Minnesota Department of Revenue. The sticking point there is that tenants will need to provide receipts, essentially proving the amount of rent that they paid. So, which is why it's so important to get a receipt for when rent is paid, so that you can, apply for this credit amongst many other reasons, right? So. Um, the again certificate of rent paid, it's something that is once a year issue, but it's something we get a lot of questions about here at Homeline, so it's an important thing to kind of touch on. All right, so I see here that it's 10:18. I've got, let's see, just a couple of questions here. We have a few minutes in my schedule, so if you have any questions about what I have talked about here quick, feel free to put them in the Q&A. Looks like Alex is asking, who do you contact to get a license? That is going to be the city that your rental property is in. If you are a tenant and you're wondering if your landlord has a license, again, you're going to call the city. Oftentimes these are handled through the fire department, but it really varies, depends on your city. So that's the research that you're going to need to do. All right, got that. All right, so then without further ado, I am going to pass it on to Philip, one of our attorneys here at Homeline, who is going to get into the forming of the tenancy. So, Philip, take it away.
All right. Good morning, everyone. Like Rachel mentioned, my name is Philip, and I'm a staff attorney here at Homeline. Can we go to the next slide, please? So before you get an apartment, the first thing you're typically going to have to do is apply to the apartment. And the landlord's going to want to make sure you're sort of a good fit for the building. So the way I think of this is there's sort of two approaches to laws that control activity. There's additive and there's subtractive. And this is a subtractive case. And what I mean by subtractive is we start with basically everything is allowed, and we're subtracting from that. So generally speaking, landlords have broad discretion for what they screen for. If they want to say, I don't like people who write with their left hand. So if you write with their left hand, don't even bother to apply. It would be weird, but they could do it. But typically what we see are screening criteria that look for two things. Landlords are running a business and they want to make sure, one, can the tenant pay their bills on time? And two, are they going to be an issue for other tenants in the building? There's sort of four criteria that landlords use to do this. They look at criminal backgrounds. They look at your rental history, right, to make sure you don't have any evictions in your record. Your credit history, right? A good indication of can you pay the rent on time is can you pay any debts that you've taken on time. And then finally, income requirements. So the Department of Housing or Urban Development has adopted sort of a 1/3 rule for what's considered not rent burden. So you take your income after taxes, divide that by 3, and that's how much you should typically be paying for housing each month. So typically landlords will have rules saying you need to make 3 times whatever the rent is in income. In Minneapolis, there's a city-specific ordinance 244.2030 that applies some more sort of restrictive rules on what landlords can look for, and it's really sort of broken down into 3 categories: um, criminal history, credit history, and rental history. So for criminal history, there's sort of 7 things that landlords cannot consider. Number 1 is any arrest or inactive case that didn't result in a conviction, right? So if you were um, arrested for a DUI or whatever, and you beat the case, there's no conviction. Even though it's probably still on your record, they can't consider that in your rental application. Participation or completion of a diversion program, convictions that have been expunged or vacated, conviction of a crime that's no longer illegal in Minnesota, right? So if you have a possession of marijuana case that you were convicted for, because that's no longer legal in the state under state law, they cannot consider that in your rental application. Any convictions or adjudication in the juvenile system, right? So anything before you're 18 can't be considered. And then any misdemeanors older than 3 years from the date of the sentencing, right? So not the date you're arrested, but from the date you're actually sentenced. Most felonies that were older than 7 years, but there's 2 exceptions to this rule. Number 1, they can always look at the manufacture and distribution of a controlled substance. And second, for sort of more serious felonies, there's a 10-year limitation rather than the 7-year limitation. And the 10-year carve out is for first degree assault, first degree arson, aggravated robbery, first degree murder, second degree murder, third degree murder, first degree manslaughter, kidnapping, and first degree criminal sexual conduct. So those are the rules on criminal history. For credit history, they can't consider, sorry, can you go back a slide? For credit history, they can't consider the credit score by itself, right? So they can't just look at the number. However, they can look at info that's directly relevant to your fitness as a tenant, right? So if you have a bankruptcy in your credit report, they can consider that. Large amounts of debt or frequent delinquency on debts compared to income. But they cannot consider insufficient credit history, right? So if you're an 18-year-old getting your first apartment in college, they can't consider the fact that you probably have no credit history unless you withhold some information in bad faith that would be a basis for denial. And then finally, for rental history, landlords in Minneapolis cannot consider any evictions that were dismissed, evictions that were settled with no judgment or writ of recovery older than a year, any evictions where the tenant lost since older than 3 years. They can't consider insufficient rental history unless the tenant withholds information that would be the basis for denial. And so in Minneapolis, landlords can use the 3 times rent amount test, but they have to allow an applicant to demonstrate a history of successful payment if their income is less than 3 times the rental amount, right? So if you can say, look, I spent half my income on housing in the past, and I consistently paid my bills on time, they have to at least consider that. And then finally, landlords have to in Minneapolis, have to allow landlords to submit supplemental evidence to explain, justify, or negate any negative info revealed in their screening. All right, if you can go to the next slide. Next slide. All right. So application fees. If a landlord accepts an application fee, the first thing they have to do is give you the written criteria they're judging your application on. And the basic idea here is before you give a landlord any money, you should know going in whether you're going to get accepted or not. And okay, all right. And then if you're denied, you have to get a free copy of the report that shows why you were denied. But you have to make the writing within 60 days. And so the purpose of this is, these companies are run by, humans who make mistakes. It's possible that John Anderson 1's information got put in with John Anderson 2's. And so maybe something in there that's just, incorrect. And so you should be able to correct the record. Additionally, consideration for applications must be sequential, right? So if John applies first, Mary applies second, and Stephen applies third, you have to consider their applications in that order. You can't sort of pick and choose which one of three qualified applicants you want to take. You can't be denied for a pending eviction or for an eviction where the writ was not issued, right? So this is sort of just basic due process, more or less. If you have a pending eviction, you may win it. The landlord may not have had a reason to evict you. Um, and so that cannot be considered. And then finally, any fees have to be returned if you're denied for a reason not given, right? So if their criteria was 3 times income, credit score of at least 600, and no violent felonies on your record, and then they deny your application saying, well, you write with your left hand, because that wasn't listed, they have to return that fee to you. Next slide, please. All right, so discrimination is sort of an interesting thing because it's something in sort of a non-malicious way everyone experiences every day, and it's something we all sort of do in our daily lives. And what do I mean by that? So if you go to Target, right, there's an area out front that's for handicapped people. They're saying this is a certain class of people we're going to let park up front. You're being discriminated against in a sense. Similarly, if your mailman knocks on your door and says, "Hey, can I come in for dinner?" You're probably going to say no. But if your friend comes in and says, knocks your door and says, "Hey, can I come over for dinner?" You would probably let them in, right? You're discriminating. I've got category people I'd let in for dinner, category people I won't. And so we're talking about discrimination. We're really talking about discrimination against protected classes. And so there's a whole list of protected classes, including race, color, creed, gender, marital status, family status, sexual orientation, religion, disability, national origin, and receipt of public assistance. And those are throughout the entire state. And then we sort of have these city-specific protections. So in St. Paul, you cannot be discriminated based on your age or ancestry. In Minneapolis, again, age and ancestry, gender identity, or receipt of Section 8 housing. So if you're a landlord in Minneapolis, you can't say, you meet all our criteria, but because you'd be paying through Section 8, we're going to deny you. Additionally, Minneapolis recently passed height and weight as a protected class. And then within that, at the bottom of the slide, you can see Minnesota statute, section 504B.315. And this is about a change of familial status. In the most often cases, right, someone gets pregnant and they're having a child on the way, or they have a child. There's also some additional protections here. So if you are in the process of securing legal custody for someone under 18 years old, right? So if you have, a brother or sister that's going to jail and you need to take in their child, that meets the requirements 504B.315. Additionally, if you have someone you're taking in who cannot receive or evaluate information or cannot make or communicate decisions, right? So if you have a parent that, God forbid, but gets dementia and they just need to move in with you, that is also protected by 504B.315. And what are the protections that law provides? Number one is you cannot, within 1 year, you cannot be evicted, denied a continuing tenancy. So they can't say, you're bringing in someone new, we're just going to cut your lease. You cannot be denied a renewable lease. So 1 year protection. And if the landlord wants to change it after that year, they have to give you at least 6 months notice in writing. And there are some exceptions there, right? So it's not a blanket protection. If you don't pay your rent, if you do significant damage to the premises, if you're a significant disturbance to other tenants, or other breach of lease, you can still be, evicted, denied of continuing tenancy, et cetera. But as long as you're paying your bills on time and you're not being a nuisance to other tenants, you've got a year protection and then 6 months notice, and this cannot be waived. Next slide, please. All right, so pre-lease deposits, these are something that are kind of going by the wayside as computers do a lot of the applications, and they are much quicker at, sort of doing the processing than when, there's a human being doing it. But basically a pre-lease deposit is, after you've applied, but before you've put any real money down, Um, some places will say, hey, can you, give us $100 or $200 just to make sure you're serious about the place. But before a landlord accepts this money, number one, they have to state the circumstances under which under deposit will be returned, right? So if they say, um, for whatever reason we have to back out, we will return your money. Or right, if the building burns down, we will return your money. Um, and the writing also has to state that the landlord will return within 7 days if any of the criteria they list are met, right? So if they back out within 7 days, they have to get the money to you, or at least get it in the mail. Um, so if you as a tenant are accepted after you put pre-lease deposit down, um, that deposit has to be applied either to your security deposit or to your rent. They can't just, take that money and say, thanks for the deposit. Now you owe us full security deposit and then full month's rent or full rent for the rest of the term. Um, all right, construction delays. This is a new law that took effect that passed in 2024. And so new construction delays can mean several things. The most really what this law was passed for is there's some college housing that wasn't ready at the start of the school year, and the law didn't really have a way to sort of adequately deal with it. So that's sort of the most common thing. But new construction can also mean rehabilitation, right? So if they're doing sort of major changes within the building and there's contracts going in and out, it's just not ready when you move in. That can also mean new construction, significant modifications or reconstruction, right? So it's not just like a purely new building. It can mean sort of remodeling or restructuring as well. Oh, sorry, can you go back? So if the new construction isn't available for occupancy at your move-in date, the landlord has to notify every effective tenant prior to the move-in and offer sort of one of three things. And it's up to the tenant to decide which one they want to take. Number one is alternate housing provided by the landlord. And this alternative housing has to be generally the same in terms of amenity, size, and location. So they can't say, we know you are renting a place in Minneapolis from us, but we found a place in Duluth, that's a, studio apartment. It's got to be sort of generally the same. Payment equivalent to the cost of the rent to mitigate alternative housing. Right. So the way you do this is you take the rent amount divided by how many days per month, and that, sort of do the math from there. And then termination of the lease agreement and return to the tenant of all the amounts paid, right? So if you just totally want out of the lease because the place isn't ready on the date you're planning on moving in, you can do so. If you go to the next slide, please. All right, pets and service animals. So to me, the big thing here is there's no requirement that landlords have to accept pets. Pets bring noise, they bring, they track in dirt with them. They're kind of messy and dirty. And so landlord can say, you know what, they're just not worth the trouble for me. If you have a pet, I'm just not going to accept you. Having said that, service animals and ESAs are different. And the way I think of this is the law sort of views them as a disability support rather than a pet or an animal, right? So in the same way, a landlord couldn't say, well, you're bringing in a wheelchair, I'm not going to let you in here. A landlord, can't say to, let's say, a blind tenant, well, you're bringing in a seeing eye dog with you, so I'm not going to let you live here. So this is regulated by both the Fair Housing Act for buildings that receive federal funding and state law. And the two really kind of mirror each other. Sort of a few big things. A landlord cannot charge fees for ESAs, either pet deposits or sort of a continuing monthly pet fee, right? Because again, they're really a disability support rather than a pet or an animal. Landlords can request supporting documentation if the disability isn't readily apparent, right? So if you're clearly blind and you have a seeing eye dog, really probably not a strong basis for a landlord to request supporting documentation. What this is kind of more common with is people who have depression or PTSD, where it's sort of not outwardly visible, and they have sort of an emotional support animal. In addition with that, supporting documentation means it's got to be from a licensed professional. There's a million websites you can go online, and you'll never see a doctor. No one will ever diagnose you, but you pay them, $100 and you fill out an online application, and they send you a letter in response. 504B.113 says landlords do not have to accept from these sort of certification mill websites. It's got to be, primary care provider, a nurse, psychologist, someone who's sort of regularly interacted with you, and has a good sense of what your disability is and how the animal supports you. Additionally, landlords may not limit the exceptions and types of breeds if you have the animal before you sign the lease, right? So if you are looking around for a place and you have an emotional support animal that's a pit bull, and the building's breed restrictions say no pit bulls, a landlords cannot say you can't bring that pit bull in. However, the Minnesota Department of Human Rights has said it's reasonable if you want to get a service animal or an emotional support animal mid-lease that you follow the building's existing breed guidelines, right? So if the building's breed restrictions say, no poodles, no pit bulls, and no Dobermans, and your doctor says, you should really get an emotional support animal, and you've always wanted Doberman, DHR guidelines say you need to follow their existing breed restrictions. Additionally, there's a few new laws about declawing and devocalization, right? So for cats, the law says they cannot force you to declaw your cats as a condition of having an animal, and they cannot require you to devocalize your dogs or cut the vocal cords as a condition of having an animal. All right, and next slide, please.
That is, in fact, the end of your
All right,
slides, but we do have some questions
all right.
for your section that we have some time to, a couple minutes to get to. So let's just go in order. So James is wondering, how can an applicant request to be refunded for an application fee if they are denied for a non-criteria listing?
Yeah, so I'd say, right, the easiest thing is just to sort of email them, right? If they had someone that, email or
Mhm.
call them if they had someone that was head even line and got approved. If they won't do that, really, you've got to go through small claims court or conciliation court to get that money back if they refuse it.
All right. This is an interesting question from Anonymous. How specific does a landlord need to be for their screening criteria? Um, if you are, do you have any insight or thoughts on that?
Yeah, so I sort of break it down, and maybe people have other opinions here. If they're not charging an application fee outside Minneapolis, so Minneapolis, the ordinance says they've got to be as specific as possible, right? But statewide, um, I sort of break it down into, are they taking an application fee or not? If they aren't, there's really no rules. They can just sort of give a general, we screen for criminal credit, rental history. But if they're charging an application fee, they need to be as specific as they can, right? So to me, like criminal would be like, no violent felonies within the past 20 years or whatever, credit score of whatever with no bankruptcies, and then, no evictions within the past however long.
Yeah. Like as a landlord, like you want to be as specific as you can be so that you don't have folks who are not qualified applying for your place because that takes up your time and as well as
Yes.
as a tenant you don't want to apply at a place that you know you're not pretty sure that you're going to get approved for. So it's in everyone's best interest just to have as much transparency as possible. All right. And then for service animal ESA, is there an expiration for, well, I'm hoping Anonymous just missed a word in here because they're saying, is there an expiration on these service animals or ESA
Um,
recommendations by primary care providers? Or does
I,
it? Mhm.
yeah, I don't believe there is. I don't think the law, as far as I'm sort of remembering off the top of my head, says anything about like it's got to be within the past, 5 years or whatever. Um, Having said that, right, if you got like a 20-year-old one, I would probably get an updated one for a doctor because to me, that would probably raise some red flags to a landlord. But like looking purely at the statute, As far as I'm aware, there's sort of no time restrictions on how recent the letter from your primary care provider needs to be.
Hmm. Right. All right. Thank you. All right. So then, uh, Philip has done his job. He's free to go. We're going to be switching over to during the tenancy now. And so during the tenancy, the thing that really starts the tenancy is the lease, right? So we are going to switch over to Amma, who, you can introduce yourself as you will, Amma, but welcome. Thank you for joining us.
Good morning, all. I'm a Carrion. I'm a supervising attorney at Homeline. And now let's talk about leases. Um, Now we submitted the application. Now we're we've been approved to the unit. And so what happens next? So you basically sign the lease. And um, a lease it's a legally binding contract between two or more consenting adults. Um, and then it has to follow all applicable laws and ordinances, both city, state, and federal, if necessary. There are a few types of leases. There's a written lease, um, and this is required for any building or property that has 12 or more residential units. So the landlord owns more than 12 or more residential units. Um, and it is required if you are entering into this contract for over a year. This is because of the statute of frauds. There are oral leases in Minnesota also, and it's about 10% of leases in the state tend to be oral. This is just you agree with the landlord, I'm going to rent this unit, um, usually month to month at this price and for this amount of time. And I say this amount of time, it's not like you agree with the landlord that you're going to be there month to month for a year, but it just there's usually an understanding that you're going to be there for more than a day. Um, in terms of the law in Minnesota, you need to have a copy of the lease if it's written, obviously. The landlord has to give it to the tenant. And the statute that we would be looking at is 504B period 115. Now, remember, this is for written leases. If you are in a month-to-month tenancy, and it's an oral tenancy, I'm sorry, an oral agreement with the landlord, there won't be a copy of the lease. But I really do recommend to both tenants and landlords to have terms written down, even if it's a month-to-month tenancy. You really want to know what you're signing up for. Next slide, please. So in terms of common leases, it could be done over the internet. This is like they send it to you so that you can sign it online. Um, there's also national leases with Minnesota specific amendments. This is very common for out-of-state landlords or corporations. They have sort of a master lease and then they tweak it so that it fits Minnesota specific requirements. It can be also something that an attorney drafts. Professional management companies, like I said, um, tend to have their own lease that it's what they share with every single tenant. It could be homemade. If you're, sort of a mom and pop landlord, you tend to just grab a piece of paper and put some terms of what is expected from both you, the landlord, and from the tenant. And then Minnesota Multi-Housing Association does have a lease that is available for people to use in the state. Next slide, please. So the basic requirements that you want to have on the lease, and this is very important. You agree with the landlord to rent a property, and so if you want to have something in writing, the basic requirements are to have the name of the party, so the name of the tenants and the name of the landlord or landlords, the location of the rental, the address, the length of the lease term. Is it going to be month to month? This is going to be like for, I don't know, 3 months, 6 months, a year? Is it going to be a multi-year lease? And then the amount of rent or the description of the services that are going to be offered. This is like I said, this is the basic requirement. This is the bare minimum you should have when you enter into a contract slash lease agreement with a landlord. Next slide, please. So Minnesota has, I mean, this really happens to every state, some clauses that are not enforceable. Minnesota-specific unenforceable clauses are things like the landlord is requiring the tenant to do maintenance or snow removal, snow shoveling without compensation. Minnesota law requires landlords to offer adequate compensation to a tenant if they are doing maintenance work or snow removal, lawn maintenance. Tenants can say, no, I don't want to do this. The most common clause you'll see on a lease is that the landlord will say rent is going to be discounted a certain amount of money, $100, $150 a month, if tenant does lawn maintenance and snow removal. Otherwise, the rent will be $150, $100 more expensive. As a tenant, you have a right to say, I don't want to do this. Like this is very important. Tenants have a right to say that they don't want to do snow removal and lawn maintenance, and they'll pay the extra amount of rent a month. There's the privacy issue. So a landlord can't say, I'm going to enter whenever I want to. As a matter of fact, Minnesota law requires landlords to give a 24-hour notice. And then they have to give a window of time when they're going to enter between 8 a.m. and 8 p.m. And within that time period, they have to provide a window of time or a specific time of entry. And they need to have a reasonable business purpose. So this is not like a situation when the landlord can just knock on the door and show up for any reason whatsoever. In terms of abandoned property, there are restrictions as to any deductions the landlord can make for abandoned property that the tenant left behind. And the key here is if you're a tenant and you move out, any property you leave behind that the landlord has to dispose of, they can deduct it from your security deposit. So you really want to take your stuff with you so you don't get additional charges. In terms of automatic lease renewals, they are allowed by law. And just make sure that you read the statute, both as a landlord and as a tenant, because there are very specific reasons or requirements that you have to provide to a tenant because, or not because, if you have an automatic lease renewal clause. Automatic security deposit deductions, we do see this often with, for example, like cleaning the carpet in your unit. And they'll say, well, this is something that we're gonna automatically deduct $100, even if there's like no damage to this particular carpet, for example. We will talk about late fees. They're capped at 8% from the amount that you owe the landlord. And then there might be some clauses regarding evictions, things that are not enforceable when it comes to evictions. Next slide, please. Cannabis is something that is now, the use of it is allowed in Minnesota. So landlords cannot stop tenants from possessing cannabis plants in their unit. However, and this is very important for all tenants in the state, the landlord can still prohibit smoking or vaping, whether it's cannabis or it's tobacco. But you can grow your own plant if you want. There is a limit as to how many plants you can have. It's just the use of it, the smoking of it, that can be restricted if a building is non-smoking. And then if you have medically prescribed cannabis, landlord can't allow vaping or smoking in multi-unit buildings. So, and this is because it's prescribed. However, if you are in federally subsidized housing, um, the federal law still applies. So the state law would not supersede federal requirements. Next slide, please. Let's go back to those fees, right? So if there's a fee that is that the landlord wants to charge a tenant for, the most common is like late rent or pet rent, pet waste, smoking fee, storage fee, early termination fees. All those fees can be allowed, but they have to be listed on the lease. Rent, as I stated earlier, has to be no more than 8% of the amount that is owed. So if you've paid, for example, half your rent for the month of May, let's just use this month, you can definitely, as a landlord, charge a late fee if the tenant paid only half of the rent, but it cannot be more than 8% of the half that is owed. It can't be the full amount of rent for the month. It's just the amount of money that is owed. In terms of pet rent, it is allowed. Um, it's just that if the tenant has a service animal or an emotional support animal, you can't charge that. Same with a security deposit, and Philip discussed this earlier. A smoking fee, that's usually when the building is not smoking and a tenant is smoking and they have to run like ozone machines or stuff like that. It's a penalty. It's fine. It's just that it has to be listed on the lease. Storage fees are just for storage units. Again, allowed. It just has to be listed on the lease. And early termination fee, this is a big one for tenants when they want to move out early. Landlords don't have to offer an early termination clause on the lease, but if they do, they have to list what the fee is. This is the key thing. You have to list what the fee is. Next slide, please. Now, the law requires all non-optional fees to be disclosed. Um, and this would be not just an advertisement, but in the lease itself. And it has to be included with the rent. So what that would look like is rent is $999 a month. There is, I don't know, a facilities fee that is required from everyone that it's, I don't know, $21 a month. And so your total monthly payment would be $1,020, and that has to be listed as such. In that it has to be on the first page of the lease. So it's fine that you have a fee for facilities, but it has to be listed on the lease, and the tenant needs to know what is really the total amount of rent that they're going to be paying, including that fee. And then the lease has to also include information of whether utilities are included with rent or not. So what we tend to see is the base rent, which is $999 in my example. You have a facilities fee that's $21 a month. And then you're going to say as a landlord, okay, and this is the utilities that are included. It would be water and sewer, and maybe natural gas, and then tenant is responsible for electric. That's just an example. It just has to be really very specific so that the tenant knows how much they're going to pay a month on rent and any other fees that they can't waive. Next slide, please. So some examples of common non-optional fees. It's a portal fee. That's just like if you use portal X, Y, and Z to pay your rent and communicate with the tenant, there's usually a fee. Let's say it's $3 a month. That is non-optional because the tenant has to pay for it in order to live there. That has to be listed. Administrative fees are other fees that has to be listed. My example with the amenities fees. Utilities fees, if charged by landlord, it's the most common thing is the tenant has to pay some sort of fee to have the payment processed. Internet or cable, some landlords do offer internet or cable in the buildings, but it's mandatory for all tenants to have it. So if that's the case, that fee needs to be listed as non-optional. There's the lease processing fee. It's pretty common too, especially with bigger corporate landlords, because the tenant can't say no to that fee. It has to be listed. And then utilities. The most common is just the fee to pay a utility, because obviously utilities vary by month. So if there's a fee to pay for those utilities, that has to be included in the lease. The most common examples of optional fees, these are fees that are not included in the total monthly rent because the tenant can say, I don't want this, is a garage or a parking spot fee, and then the pet fee. Again, taking into consideration that for emotional support animals and service animals, this fee cannot be assessed on a tenant. Next slide, please. Now, utility billing. This is part of the new law. There was a change in how utilities were going to be billed for buildings where the landlord really handled utility payments. And so in the case where the landlord handles utility payments, well, the landlord pays the utilities for the building. It's a shared meter situation. It can also be that the tenant pays utilities directly to the provider, so Xcel Energy or the local water company. And then if the utility usage is measured by submeters and tenant pays for usage separate from rent. So that means like your rent is $999, and then there's this other fee for utilities where you pay, your variable rate for water usage or power usage, depending on what you've consumed on a specific month. Next slide, please. So what is a shared meter residential building? This is a building with multiple separate residential dwellings. But the building's utility service is measured by a certain amount of meters. It's not one per unit. Let's say it's like 2 units per meter. So when that happens, this is called a shared meter residential building. This is not something that's included in manufactured home parks, though. So before, the landlords just had to provide a formula that said how they were sort of subdividing or proportioning the utilities within or amongst tenants. Now there's very specific formulas so that the tenants know what they're actually paying for. So for gas, what the landlord can look at is the square footage of the tenant's units as a proportion of the square footage of all the units in the building. And that's how the gas is at proportion. For water, it would be the number of tenants on the lease as a percentage of the total occupancy in the building. So if you're in a unit and it's 2 people and this is a building with 30 units, then that's how it would be looked at. The amount of people on your lease and the occupancy on the rest of the building. Apportionment of electricity is no longer allowed, and this is effective January 1st, 2025. The landlords cannot charge for common area utility usage that had become more common as of recently, so that's no longer allowed. And then there's a limit on the fee the landlord can charge for administrative billing of utilities. It's capped at $8 a month. For late charges, if the tenant is late paying the rent, the cap on what the late charge can be is $5 a month combined for all utilities. So if the landlord is billing the tenant for gas, water, and electric, the cap on the late charge is $5 a month. Next slide, please. In terms of modifications to the lease, there can be modifications to the lease clauses. That's not necessarily uncommon. This is very typical, obviously, in term leases. If it's a term lease, the modification to the lease can only be made by mutual agreement of all parties. So that means that the tenant and the landlord both agree to make a change to the lease. If it's the end of the lease, the changes are generally allowed, but you have to give the tenant proper notice. So that would be like you're up for a lease renewal, and let's say rent is increasing. So they have to give you proper notice, and that's tied to the notice period in your lease. If you're in a month-to-month tenancy, for example, and you have a 60-day notice requirement on your lease, then any changes to your lease agreement has to receive that 60-day notice before it goes into effect. So the change can happen, but proper notice is key. The most common changes that we tend to see that landlords want to make, it's like there's rule changes. Besides the rent increase. And that's coming from the landlord. In terms of tenants, what they tend to ask landlords the most is to add a pet to the lease, to sublet the unit, which the landlord has a right to say no to, or to add tenants to the unit. Let's say your partner is moving in with you. Next slide, please. In terms of early lease renewals, there was a tendency, especially in college towns, to have landlords ask tenants a month or two after they moved into the unit to ask the tenant if they wanted to renew the lease for the next year. I'm sorry. So now there is a limit on that. So for leases that are 10 months or longer, the landlord cannot ask the tenant to renew the lease during the first 6 months of the current lease. So you have a 12-month lease. The landlord has to wait for 6 months to go by before they can ask you if you want to renew your tenancy. Like I said, this was more common in college towns. This is just really tied to, you know, students renting houses and with other roommates. And so landlords wanting to make sure that the property in this college area stays rented year round. So now there's a limit. There's I guess a protection for the tenants. Landlords have to wait a little bit before they go ahead and try and renew the lease. Next slide, please. Now, roommates, my favorite topic. Um, if all the roommates are listed on the one lease, they don't have individual leases, there is joint and several liability. What that means is you are responsible as a tenant for what your roommate does. So you might have an agreement as to how you're going to pay rent. Like I'm rooming with Jane, and the rent is $1,000 a month, and so we each agree we're going to pay $500 of rent a month. But Jane decides or that she wants to move out, she's not going to be paying rent anymore, or she can't pay rent anymore. I'm responsible for her portion of the rent. The landlord just cares about receiving the rent as agreed, and any other agreement I might have with my roommate doesn't really affect the landlord. They need to get the rent, and I'm gonna have to cover Jane's portion of the rent during the period of time that she's unable to pay rent. If there's damage to the unit, you're both equally responsible for the damage. So you have a little party and someone punches a hole in the wall, and Jane's like, I'm not going to pay for that, even though it was my guess. I would be responsible for fixing that hole in the wall. If there is an unauthorized permanent occupant, that might be grounds for eviction. So that means that, I'm living with Jane, and I have a partner now, and my partner wants to live in the unit with me. That person's not on the lease. the landlord now has grounds for eviction because there's an unauthorized permanent occupant that's living in the property. Um, and then this is a very important thing. If one roommate gives a notice of lease non-renewal, that ends the lease for all the roommates in the unit. So make sure that as a tenant with roommates, you have really good open communications with your roommates so that you can all decide if you don't want to continue renewing the lease for the future, because one notice is all the landlord needs. Next slide, please. Oh, I guess that's the end of my part. I believe
Yeah,
Mike
there's
is
a couple.
up.
No, well, first we got some questions for you.
That's
And then
right.
we'll have the Matt hour. Um, but we do have a couple of questions. So thank you very much for all of that. Like I said, we're running a little ahead of time, so I'll go ahead and ask those questions that have kind of come up. Now, some of these I think are things you've covered, but if you want to just quickly reiterate what you've
Okay.
said. So Rob is saying that they sometimes see lease terms like if client is evicted, they are still responsible for paying rent until the unit is re-rented. Are these terms legal or enforceable in Minnesota?
So they can definitely send it to collections, right? The thing is that now for leases that started January 1st, 2025, landlords have a duty to mitigate. So let's say I get evicted, um, and I move out. The landlord can charge me for what's owed, and they might send the remainder of the lease term to collections. However, landlords have to try and re-rent the unit. Um, so it's a yes and a no. Um, the landlord really has to try and rent the unit because ultimately what they're trying to do is get money for the space that they're renting. And so if you just let it sit there, you're going to be at a loss. Um,
Yeah, I always think of it as like the lease is the contract, right? And the landlord
right?
had a reasonable expectation to have the income through the that lease term. And so if they're suddenly denied that for whatever reason, then they can try and recoup that loss,
Correct.
whether that's through the
Um,
original tenant or from a new tenant if they re-rent it.
correct. And the big thing here is if the landlord re-rents the unit, they can't double dip. So that there is a protection for the tenant. There is also a protection for the landlord because you're getting possession of the unit and you're able to re-rent it hopefully as soon as possible.
All right. Donna is reiterating what you said about cannabis, is that marijuana is still illegal at the federal level, and so things like HUD subsidized housing, it's regardless of what Minnesota law says, as you
Correct.
said, it's still illegal in those
I,
properties, right?
I mean, and this is something that tenants really need to be concerned about, especially in subsidized housing. Um, there are other ways that you can consume your your medically prescribed marijuana. Um, so perhaps go that route.
Yeah, just be aware of what sort of housing you are living in. I think
Correct.
that's clutch as well. All right, and the anonymous um, is saying, so really gives a nice breakdown actually of the total rent in the advertised uh, rental rental advertisement. That's the proper order of words that English has requested of us. Is it required for total rent payment to be calculated for renters in advertisement and in the lease? For example, a landlord could list the rent as $900 per month with a non-discretionary fee for $50 for utilities and a monthly total rent of $950. Do advertisements need to show the final calculation of $950, or is it okay to list the base rent and additional fees as line items?
So they have to include it as total monthly rent. You can say, $900 for the unit, $50 for a non-discretionary fee, and then at the end it has to say total monthly rent for the tenant. And it's an advertisement, and it's everywhere, basically. The tenant needs to know what they're going to be paying.
All right. Um, So if a tenant is letting someone stay illegally at their apartment, not on the lease, sorry, I'm going through these quickly. Some of these questions are going to be more specific than we're going to be able to have time to get into
Okay.
today. Um, So if there are issues like with other tenants or neighbors or things like that, who should a tenant talk to?
So the tenant should always notify the landlord if
Okay,
there's issues with a neighbor.
perfect.
I am always very hesitant to tell people just go knock on the door and try to have a conversation because you could get into a serious argument. So you can knock on your neighbor's door and just be very calm, collected, demure. Um,
Of
but
course. All right.
um, but really notify the landlord. At Homeland, we do have a letter that you can send the landlord, just a neighbor violation letter, just said that they're aware that there's a situation. If
Hmm.
noise complaints are sort of the most common, you can call the police non-emergency line. It's just when you're communicating with anyone else, be that the landlord, a neighbor, or the police, you really need to be respectful and keep your wits about it
Yeah,
because you don't want to escalate a situation.
absolutely. Thank you so much, Emma. I appreciate you. We are going to shift over now to tenant rights. So we will be getting Matt in here. So feel free to, you can stick around, Amma, or you can put yourself
On
off
mute,
video and on mute and go about listening to what Matt has to tell us about tenant rights.
Matt the lawyer.
Matt the lawyer, yes.
Yes, that's my title, Matt the lawyer at Homeline. Yes, and I'm here to talk about tenant rights, sort of the tenant side of the equation. What obligations and what duties are owed to the tenant? So let's go to the next slide. So these are the six big categories of tenant rights we'll talk about. We'll talk about right to repairs, what to do if there are emergency repairs. We'll talk about a tenant's rights to privacy. Some of this has been mentioned before, and that's good. We always like to circle back. Right to have guests, a tenant's right to make emergency calls, and tenant's rights to organize at the property. So there we go. Let's start with repairs. Repairs, uh, the duty to repair is probably the landlord's largest duty owed to the tenant. It is, I think, the most important thing for a lot of tenants is having a property that's in good repair. In a lot of ways, that's the whole idea behind renting, is that you will pay money on a monthly basis and you don't have to make the repairs. That's like the fundamental idea for a lot of tenants out there. So it's a big part of the contract. It's a big part of the law. It's a big part of what we do at Homeline. Uh, Easily the number one reason people call Homeline any given year. So, what are the obligations of repairs? It's found in Statute 504B161, what the statute calls the covenants of habitability. These are the promises to keep the property habitable. More specifically, a promise to keep the property fit for the use intended and in reasonable repair. To make the common areas and the premises reasonably energy efficient, to comply with local health and safety laws and ordinances, and to furnish a minimum amount of heat to the property. Uh, those are the big things, right? When a person goes to rent a property, that's what they want, right? The oven should heat up to 450 degrees. The toilets should flush. The windows should open and close, right? Uh, there shouldn't be all kinds of holes in the wall, right? These are things that are reasonable repair, right? Things that are fit for the use intended, that the air conditioner should condition the air, right? So that's really what the tenant is entitled to. That's what the landlord promises to deliver. Um, More specifically, the heat code is a new update, recently new as far as law goes. These things change slowly, and so new changes take a long time to get sort of into people's minds. But the statewide heat code required to provide 68 degrees from October 1st to April 30th is what the requirement is. We see a lot of there sometimes are attempts to shift the burden of repair to tenants. Um, Amma talked about this a little bit when it comes to lawn care. It's the same for other repairs also. Um, it can be allowed. It can be allowed if the um, lease allows it, essentially, that the lease says the tenant will do these repairs and the lease allows the tenant payment or a discount on the rent to do the work. Um, Short of that, And I think it really needs to be a specific amount of money. I don't think it's sufficient to just put in the lease. Tenant will maintain the premises. Tenant will handle all repairs. Tenant will make all repairs that cost less than $100. That's not enough. There needs to be sort of this additional consideration, this additional payment. The exclusion, of course, is who causes the repair, right? That's sort of a secondary issue is what if the tenant breaks it, right? Is it the landlord's job to fix the window if the tenant was playing baseball in the living room? That answer is no, right? If the tenant causes the damage willfully, maliciously, intentionally, irresponsibly, right? I would say playing baseball in your living room is irresponsible, right? Then it's the tenant's job to make those repairs. So the question then is always to me, what can you do about it? Right? So what can you do about it? If I'm living in a property and the toilet won't flush and the oven won't heat and the refrigerator won't cool, what can I do about it? A tenant has a few options here. The most common option I recommend is what is called a rent escrow action. What it is it's a lawsuit the tenant files where they pay their rent to court instead of paying it to the landlord. You get a hearing in front of a judge, and as a tenant, it's your job to show the court, here's what's broken, here's what needs fixing, here's how the landlord is not living up to their end of the bargain. And the judge can decide, right? What's broken, what needs fixing, who's responsible for it, right? The judge can order the repairs made. The judge can award a discount on past and future rent. The judge can allow the tenant to make the repairs and deduct them off the rent themselves. The judge has a pretty broad hand. They can appoint a third party to administer the property, right? The judge has a pretty broad hand in what they can do in these situations. And so that's what I recommend most tenants start with when they're thinking about how to get repairs made. How do you file a rent escrow? The first step is to send a letter, put it in writing. This is sort of a fundamental thing I tell people when I'm doing general talks, right? Get it in writing and put it in writing, right? Words are wind. It just comes out of my mouth and disappears into the air, right? So put it in writing. Here are the repairs. We make them in 14 days. Statute requires you to give the landlord 14 days to make the repairs. If they're not made, you can file a rent escrow case. I've got withholding rent as a remedy, right? What you can do about repairs. The rent escrow is a way to withhold the rent without sort of withholding the rent, because the other way to do it is to just tell the landlord, I'm not paying this until you fix it, right? And that's legal to do. A tenant has the right to do that. I often don't recommend it for a lot of reasons. The first reason is the landlord's response, right? What their remedy is to file an eviction action. I guess it's to fix it if it needs repairs, but it's to file an eviction action. And eviction actions are not fun. They are, in fact, terrible. I don't like that as a place for a tenant to be. But the tenant has a right to do it and go to the eviction hearing and say to the judge, Your Honor, landlord hasn't made the repairs. I've got the money right here. I want to pay it to court, and the landlord shouldn't get it until they make the repairs. And then the judge can make a lot of the same decisions as they can in a rent escrow case. What's broken? Who should fix it? Should money come off, right? All these things the judge has the right to do. But you're in eviction court instead of escrow court, and there's just a lot more risk when it comes to an eviction action. So I tend to recommend escrow as the way to go. Landlord defenses, what can they say if they're in either a Fritz defense situation or they are in a rent escrow action? The repair problem doesn't exist, right? This is not a problem. This is not a breach. It's working fine, right? The tenant caused the issue. We talked a little bit about that, right? The tenant broke it themselves or their guest broke it themselves, right? I tried to fix it, but the tenant wouldn't let me in to make the repairs. That's a valid defense. So it's important to know that court is where decisions get made, right? The tenant can have an opinion on a repair, and really this is anything, right? The tenant can have an opinion on their security deposit and what should be returned, or the repair condition and what should be made and what should be fixed. And the landlord can have their opinion on what should be fixed or what should be withheld from the deposit. And those opinions are great. My opinion is great on that too. but it's not the one that really counts. It's the judge's opinion who really counts. And so this is court. This is your chance to decide. The judge decides who owes what to who, what needs to be done. And that's your chance, whether it's eviction court, security deposits. It's the judge who decides ultimately. And retaliation, I believe we've got some slides on retaliation in the future, but there are protections for the tenant who wants to ask for repairs. This is a very nervous thing to ask for repairs. The concern is if I ask the landlord to make these repairs, what if they decide they don't want to rent to me anymore? And then I got to move, right? That's stressful. And so there are protections. There is a presumption that if a tenant asks for repairs and the landlord does some negative action against the tenant within 90 days, it's presumed to be retaliatory. So there are some protections there. The landlord, as always, has a right to prove their case, right? To say, no, this isn't retaliation. I do have this other independent business purpose for taking these actions. So those are really the repair remedies that most tenants have. And it really, for tenants, it starts with sending a letter. 14 days. We got a good form letter on our website worth checking out, but it could be an email also. So that's good to know about. Let's go to the next slide. This is all well and good, Matt. 14-day letter. I love the sound of it, but what if it's January and there is no heat? Then what am I supposed to do, right? Wait until February before I can do something about it? And the answer is no. There is an emergency provision for emergency repairs, right? A summary provision. And that's called the Emergency Tenant Remedy Action. You can file one of these if there are, like I say, emergency repairs. Statute lists them out. We're talking about lack of heat, well, they're all here. How about I read them in order? A pending condemnation issue, right? Where the city says you're not going to be able to live here anymore, right? That's deemed as an emergency repair along the lines of heat, right? No running water, no hot water, no electricity, no toilets, right? These are things that we assume we need to have like a livable and functional place, right? A refrigerator that is not working in a property where refrigerators are provided. No, not every apartment comes with refrigerators. Most do in Minnesota. It seems to be sort of the unsaid agreement here. I believe in some places, I believe in California, it's pretty common not to have a refrigerator with your rental, which is interesting. They do things differently there, and everybody does things differently everywhere. But again, some other things, an air conditioner, right? If air conditioning is included in the property and it breaks, that's grounds for an emergency tenant remedy action. The air conditioning season is a lot shorter than the heating season, obviously, but still, it's a real problem, especially older houses built for heat retention, right? You lose heat in one of these old houses, you're gonna have a real or cooling in one of these old houses, you're gonna have a real problem in July and August. No functioning elevator when an elevator is provided, right? That's a real problem for people. And then there's sort of this kind of, other category, right? Conditions, services, or facilities that pose a serious negative impact on health or safety or other essential services, right? These are, for serious things, right? This is not my microwave broke and I can't have popcorn now, right? It is 52 degrees in my apartment and it's January. So that's how you get into court if it's an emergency repair, as opposed to the non-emergency rent escrow. How do you actually file the case? That is like I said, the emergency tenant remedy action. And it's all sped up. It's the rent escrow, but sped up. Instead of a 14-day written notice, you're allowed to give a 24-hour verbal notice. It can be left on a voicemail saying, this is Matt at 1238 Main Street, apartment 2. You need to have the heat fixed in 24 hours, or I will file an emergency tenant remedy action. It gets to be 11:30 on, well, not May 9th, but you know what I mean. I can file, I'll have a hearing. Usually 3 business days I'm in front of a judge. It's pretty tough to get into court before that. And then the judge has basically the same remedies as in the escrow case. All right, let's go on. Let's talk about privacy. This is an interesting category for me because I really view landlord-tenant law as a strange sort of balancing act in a lot of ways. The contract itself is a balancing act, right? On the one hand, you have the landlord's investment in this very expensive property, right? We're talking about in the hundreds of thousands of dollars, maybe more than hundreds, right? And their desire to keep it functional and operational and in good shape, right? Because it's their asset and it's their property. They own it, right? And on the other hand, we have the tenant who has an interest in their home. This is where they live. This is where they sleep at night. This is where they go to be, secure from the world around you, right? Think of all those things that a home means to you. That's what it means to a tenant. And so how do you balance those two interests? Because a lot of times they're the same, right? Talking about like a leaky pipe, the landlord wants to fix that to protect their investment. The tenant wants that fixed because they don't want to live in a flooded place, right? Those interests are aligned, but sometimes they're not. And so how do you balance those interests when they're out of line? And privacy is where we see those balances and those interests in conflict the most, I think, because the landlord needs access to their asset, the tenant needs to be left alone in their home. And so how do you strike a balance? What balance has been struck? That's 504B .211 is the current balance in statute, and that's what the legislature does is decide how to balance those things, those interests. And so this is the balance. The landlord has a right to enter, but right, they have to give 24-hour notice. They have to give a window of time when they're going to enter. I always say, hey, the cable guy can give you a 3-hour window. So can the landlord, right? And the landlord is restricted from when they can come in, right? They're restricted from coming in between 8 a.m. and 8 p.m., right? Can't come over at 9:30 and start doing repairs, 9:30 at night and start doing repairs. Of course, landlords and tenants can agree to an earlier time, right? The landlord has to have a reasonable business purpose. They can't just come over because they feel like it, because they're lonely, right? That's not what you can do. Making repairs, performing maintenance, right? Showing the unit to prospective renters, right? A city inspection, prospective buyers, right? If you don't have business, don't go to the rental property, right? So that's sort of the fundamental balance that's been struck is a 24-hour notice, and you got to have a reason to do it, and you got to give a time window for when you'll be there. Of course, there are exclusions, right? There's always the rule and the exclusion, the exception to the exception, and then a caveat, right? There's always this like chain of things to go through. The exclusion here is, what if it's an emergency, right? If the water is leaking from apartment 302 into 202, does the landlord have to wait until Friday at 11:30 before they fix it? No. If it's an emergency, they can come over, but again, it needs to be an emergency, an actual emergency. It's worth saying, what if the tenant isn't home? If the tenant isn't home when the landlord enters, no reasonable notice given, the tenant has to leave a note in a conspicuous place saying, we were here, we were in your home, right? That's what you would want. This is the deal. The deal is the deal, right? I think it's important to say also, this isn't about necessarily scheduling, right? I think it's good to schedule with the tenant and say, hey, what works for you? But also, you don't always have to. This is, in a way, a one-way street, right? If the landlord gives a 24-hour notice, gives the window of time, then they have a right to enter, and they have a good business purpose. Then they have a right to enter. That they aren't restricted by the tenant having to be home at the time. Sometimes it's good to work with the tenant in that fashion. Sometimes because it's nice for things to go smoothly. But you sometimes just have the right. So contrary lease terms unenforceable, 504B211, you take a look at it. And then we get to what can you do about it, right? What if the landlord violates the privacy rules? $500 per violation is what the tenant can seek. They can seek a break lease order, return of the security deposit. Theoretically, there's an argument for criminal trespass. Only when the landlord meets those criteria are they allowed to enter the property. If they don't meet the criteria, they aren't allowed to enter. When you're entering someplace you don't have a right to be, that's trespassing. I haven't seen it charged, but it's, you think about this stuff enough, you start thinking about these little weird things, right? So tenant can bring these privacy claims through a rent escrow, an ETRA, a tenant remedies action. We might not talk about that. It's an interesting case. Or conciliation court for damages. So that's really what the tenant can do about it. All right, let's talk about guests. We're moving on. We're doing great. I'm getting hungry, so that's going to keep me moving. Again, this sort of goes back to the tenant's home here, right? We like to have people visit. We like to eat dinner with people, watch ball games, whatever it is, coffee, right? Whatever it is people do with people. You've certainly got a right to have guests. But the landlord can put some limits on the guests. They can say how long someone can stay, right? The landlord may have some right to trespass people. They sort of an open question, right? I think what's important here is that, again, this is that balance of tenants having the right to have people in their home and have guests, right, and live their lives, and the landlord having interest in who is staying here. Are they going to trash the place, right? Who exactly am I renting to? And as a landlord, I have a right to contract with the people I want to contract with, right, or contract with. So a lot of this guest, how long does a guest stay? How long do they have a right to be there before the unauthorized occupant? A lot of it comes with people having friends over for a little bit and then they overstay, and it gets to be a messy situation. But as far as guests go, tenants have a right to have guests, have rights to people come over, have a right to have people visit. That's allowed. I think it's worth talking about sexual harassment here. This sort of also falls into a subcategory of the discrimination laws. But it is worth talking about because it happens and it's bad, right? Unequivocally bad. This can include a lot of things, right? It can be a hostile environment. It can be a quid pro quo. We've seen and heard a lot of stuff here at Homeline over the years. Probably one of the most egregious ones I recall, the tenant had fallen behind on the rent and the landlord texted a menu of services, right? A list of services the tenant could provide to work the number down. And that's like as disgusting as it sounds, right? Um, if you're a landlord, you got to be careful who you hire. You have to be careful how you approach some things. I do hear about maintenance men, right? Maintenance men trying to get dates from, and look, I say maintenance men, and honestly, it's a lot of times it is the men trying to get dates from tenants, and that's a hostile environment. How is a tenant to respond if they say no? What next? Are they going to be given a non-renewal notice? Repairs aren't going to be made because they said no to this person's advances. So as a landlord, you have to be careful who you hire. As a landlord, you have to be careful and keep track of yourself here, right? Because what can the tenant do about it? File fair housing claims. They can file it on a state level. They could file a federal fair housing claim. They could bring a private claim for a private discrimination action claim. And it can get to be very expensive. And it's just a bad thing to do. So shouldn't do that. There we go. All right, emergency calls. Tenants have a right to call for assistance, emergency assistance. Some cities are take an interesting approach to this, and some landlords have then respond with that approach. But I have seen landlords who have put in their lease, don't call the police, basically. But we want people to call the police when there are crimes happening. We want them to call the fire department if there's a fire, or an ambulance if they need help. I think some cities are hard on landlords if there are a lot of police calls and they become sort of known as a problem property, right? And that sometimes motivates landlords to, maybe don't call the police so much, right? I don't want trouble from the city. But that's not good either for a lot of reasons. So I think it's good to call the police when you need help. The real question is, why is someone calling, right? Are you calling because you're reporting a crime, or are you the reason the police are coming? So just be aware, tenants got a right to seek emergency assistance. Organizing. Tenant organizing is something that Homeline sometimes helps with. Really, I think of it in terms of large scale landlords where bad things are happening, right? You can read the newspaper and see landlords who have done poor jobs at being landlords, and sometimes an individualistic approach works, right? We talk a lot about what a tenant can do, but sometimes the situation requires a group of tenants and what a group of tenants needs to do. There's that situation with that building in downtown St. Paul, right? It's in foreclosure, it's getting condemned, right? It's a huge mess. I don't know that one person could have made a difference to solve that problem. Maybe a group of them could have, right? A big organizing effort, maybe. I don't know. I don't have a magic 8-ball or a magic crystal ball, whatever it is that tells the future of the past. I don't know which one it is. But organizing, a tenant has a right to organize. Tenants have a right to organize. They have a right to communicate with their other tenants, talk about what problems they're all facing, and go to the landlord and say, hey, we got problems here and we want to see them fixed. That's really, I think, what organizing is about. And you have a right to do it, right? I mean, you could talk to whoever you want. This is America, right? So what are some organizing activities that are protected? Distributing information and leaflets in common areas, handing them to individual tenants, contacting other tenants through the mail, telephone, email, right? Talking with tenants to offer tenant resources or tenant organizations. Participating in tenant association organizing activities, convening meetings at the residential property to talk about the situation. I have definitely heard landlords forbid, I think, all of these things. No, you can't hand out those leaflets. No, you can't talk to other tenants about this. I can't talk to other tenants about a leaky roof. Are you kidding me? Right? What is this? So we hear that, right? And it's the rare instance of a bad landlord who does those things, but of all the lease, I've seen a lot of lease clauses, landlords who've had one bad tenant, and now there's a lease clause about tenants are forbidden from putting concrete into washing machines, right? And so we've had bad landlords who didn't want tenants to talk about leaky roofs, and now we have protections for organizing. So just be aware that that's a right tenants have, is to talk with each other. Going on to retaliation, I mentioned it a little bit up in the repair issue, and so I'll talk about it a little bit now, a little bit more. The key thing about retaliation is that I view it as a shield and not a sword. It is not a lawsuit you can bring against your landlord, like a suit to force them to make repairs. It's a defense you take up against a landlord who has, acted wrongfully against you. So it's a shield rather than a sword, right? It's a defense to a negative landlord response. It starts when a tenant asserts their rights. This is, again, the important thing about putting it in writing is that you've got a record of when precisely you asked for those repairs or asserted your rights to privacy, right? It gives you this level of protection against negative actions. What sort of negative actions are common? A rent increase, right? A notice to vacate or non-renewal, filing an eviction action, some sort of reduction in services, right? A landlord might say you can't use the exercise room, or if I see your car parked in the lot, I'm going to tow it, right? These are examples of retaliation a landlord might take against a tenant. There is a 90-day window, and I think it's important to talk about it. There's a 90-day window that opens up from when a tenant asserts their rights. During that 90 days, it is presumed that the negative action taken by the landlord is retaliatory. After the 90 days, that presumption shifts. The presumption is then that the action was not retaliatory, and it is the tenant's burden then to show it was in fact retaliation. And you can imagine how this could work out, right? A tenant asks for repairs, a tenant gets a notice of a rent increase. The tenant might say, hey, this is retaliation. I asked for repairs a week ago, and now you're giving me this rent increase. Maybe it is. I don't know. But maybe also the landlord can show they gave everybody rent increases. In that case, it's not retaliation, right? This is not singling out the tenant. This is a reasonable business purpose that they receive this, right? Thinking about after the 90 days shifts, tenant gets a notice to vacate day 91. I mean, it's the tenant's job to show ultimately. And then this takes us to the difficult part, right? Where do they make that showing? Um, retaliation, like I say, it is a shield, it is a defense. You would make that showing ultimately, I think, in eviction court. If the tenant received a notice of a rent increase, they wouldn't pay it. I think I'd recommend they send a letter saying this notice is retaliation, no legal effect. I'll pay the old amount of rent. Thank you. They pay it. And if the landlord believes that they did give a legal and valid rent increase, they should file an eviction action. And at eviction court, the judge will decide, was this retaliation or was this not retaliation? And that's what makes the retaliation defense difficult, is that it takes place in a high stakes arena of eviction court. We'll talk more about eviction in the future, of course, after lunch. And when it comes to a non-payment case, like in this example I'm talking about, the judge would ultimately say, tenant, you have a right to redeem. I find the landlord's action was not retaliatory. Tenant, you have the right to redeem. You could pay and stay. Have to pay the landlord's court costs also. That's sort of what we're looking at, is what would be at stake. Judge rules for the tenant. Landlord take the money they offered. Case dismissed and expunged. But we'll get into that more after lunch. So that's retaliation. Okay,
Right.
let's move. Oh, yeah.
I'm actually going to pause you, Matt, because I know
Yes.
your next section is on foreclosures, which is
Yes.
a whole different ball game. So I want to touch, because we're doing well on time. Well done,
Yeah.
everyone, so far this morning, by the way. So I want to touch on the questions that have come through specifically about tenant
Yeah.
rights before we move into foreclosure things. What a nice mug
Yeah.
you have, Matt.
Hey, that's right.
Um,
Branding.
Yeah. So, Anonymous, this came in right after Amma stopped. And so I just want to address this one really quick myself.
Mm,
They're saying with the new law changes this year, landlords are not able to bill back electricity on shared meters. That's not entirely true. There's a 504B.216 is the statutory regulation of how this uh, submetering and shared meters work. But it has, as with many statutes, kind of, links within links to the more specific statutes. And so actually 216B.023, which I'm sending you now, um, specifically says that a landlord can bill separately from rent for electricity, but they cannot apportion the service. They have to charge for the actual usage for that tenant. And so I know that seems like it's splitting hairs, but with the other ones, you get a percentage based on the total amount of use in the building. But for electricity, you have to do what the tenant has actually used. All right, so that's my bit. Um, so now into yours. Nanis is wondering, does it cost to have an escrow account?
yes. It costs $75 to file. Depending on your income, you can ask to have the filing fee waived.
Mhm. And that can vary from court to court.
Yeah, it's the same as the conciliation court, and so usually it's 75 or 80, depending on the county.
Yeah.
Yeah.
All right. Anonymous is wondering, can tenants make minor repairs themselves? And should the tenant then let the landlord know of what they are repairing these things themselves?
That's a really good question, for a lot of good reasons. I think it gets to the difference between sort of like the textbook answer, right, and the real world answer, right? Not that one answer is real and the other is somehow not, but sort of yes, it can be okay to make the repairs yourself. You're taking on some risk if you just do them, because what if you do them wrong, right? That's a problem. But if you're fine making a repair and you call your landlord and say, hey, I don't know what am I looking like? My ceiling fan isn't working, but I'm fine putting in a new one. If you just like, if I send you the receipt, is that fine? We'll kind of take it off the rent. And the landlord says yes to that. No problem. That's fine. Get it in writing, of course, right? I'm always a big get it in writing, put it in writing guy. Emails, texts, I think that's fine for that situation. Um, so I think that's fine. You don't want to call the landlord for every single minor repair, right? You maybe don't want to be a pest. Maybe the repair is minor and it's not worth sending a letter over. Um, you'll have to use your judgment, of course. Fundamentally, I think giving legal advice is about sort of explaining what the potential risks are and letting the client decide how they'll approach that risk, either by mitigating it or accepting it, right? And so I, with the ceiling fan example, I wouldn't do a ceiling fan because electricity does frighten me. It's
Understandable.
it's scary. um, but you know, something something minor, more minor than that, maybe it would be fine, and I wouldn't have a problem doing some small repair. So it's going to be a little bit about the tenant, right? How much do they want to push it? Could something really bad happen if I screw up this repair? That's the thing to think about.
Yeah, because then if something does go wrong, the tenant can be liable, and it could even be grounds for an eviction, right?
Yeah,
Because
it looked really easy on YouTube. Is not a great legal defense.
oh, we should get that tattooed somewhere.
Well, yeah, we really should
All
put it in
right.
my garage.
Right. All right. Rob is asking, are there any limits on the amount of times a landlord can request to come to repairs or maintenance, et cetera, in a month? I have seen cases where a property owner comes over every week to do something like painting around a light fixture or doing extremely minor things despite the tenant vocalizing and giving written requests for them to appear less.
Yeah, is the landlord using the excuse to come over for repairs as like a form of harassment or something like that? That's a really, really good question, and really gets into the nuance of how people are, right? Maybe that's not even nuance, but some people are just kind of weird that way. Um, I think it's all right for the tenant to say, hey, this is too much, right? This is, you've been here every single week, you've been here every other day. This is no longer my rental because these are not reasonable. You can do these things at once. You don't have to do them every day. And it's certainly in extreme cases, it could be unreasonable. It could be a violation of the statute. Even if they're giving 24-hour notice, it's still, you still have to respect the idea that this is the tenant's home. This is where they live, and this is their home, right? Everything that home means, that's the tenant's home.
Yep. All right. Da, 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 da. Anonymous is wondering, are landlords required to fix small wear and tear things such as like clogged sinks or showers, change out light bulbs, change out batteries and smoke alarms?
Yeah, when we went away from being in the office every day, we went away from sort of that like not exactly goofing off, but when you're just kind of hanging out with people and you work in some area really closely, you start to think about it really in a detailed way and kind of a goofy sort of way. You have conversations about, hey, what about this? Right? Uh, It's one thing I sort of miss about not going to the office much, right? And so does a landlord have a duty to change a light bulb, right? That's something that came up at the lunch table once, right? This is like great like lunch table conversation stuff, right? And I think it gets to the question of what is fit for the use intended and in reasonable repair. Did the tenant break the light bulb by being irresponsible with it, right? Did they willfully or maliciously, right? And it also gets into the question of how much effort is the tenant really going to make to, like, yeah, if the tenant used the light bulb and only used it by switching it on and off in the way it was made and it burns out, I guess it's probably the landlord's responsibility. But is a tenant going to file a rent escrow case over the light bulb burning out? No, they're not. No. I I did have a tenant want to sue over the microwave, the little spinny thing in the microwave quit spinning. This is years ago. And I was like, no, this is a bad case. You do not want to file that. So it's a great sort of how far does the law push, right? But there's no real distinction between light bulbs or smoke alarm batteries. I think a smoke alarm battery, you want to change that as a landlord. I mean, again, this gets back to this is your valuable asset. Um, I'd be pissed if my tenants pulled out the batteries on the smoke alarm, right? Like that's how we're going to save the place if there's a fire.
Yeah. All right. Alex is wondering, they've got a retaliation question. Uh, I think I understand what is being asked. Would a landlord running a background check on a non-resident, um, if the resident or the non-resident, the person they're doing the background check on, if one of the other residents that's already a party with the landlord has an HRO against the applicant? Is that somehow
That
retaliatory?
that's a tough question to answer. It sounds like it's super specific, right? And
Yeah,
so it's a tough one to. I'd want to ask a few more questions
sure.
about exactly the situation. So it's hard to answer in this
Yeah.
venue.
I would say, if the person that, if it's a background check and you don't have a relationship with this person, like you're not a tenant landlord relationship, then retaliation doesn't apply because retaliation applies to negative actions to a tenant.
Yes, that's right. Yeah. Yep.
Yeah. All right. Cool. Let's move on. We got 10 minutes, and so we should move on to foreclosures.
Yeah. Let's talk foreclosure. So, in a long ago world in 2008, Homeline hired me. Um, it was the middle of the foreclosure crisis, and some grants came in to help tenants whose landlords were getting um, foreclosed upon. This was something nobody had dealt with, right? This foreclosure crisis was brand new to everybody back then. And my boss, Mike, who you'll be hearing from earlier, called me and said, Matt, we got this grant to come in and advise tenants whose landlords are in foreclosure. It'll be for a year, maybe two, but do you want to work for us? And I said, sure, a year, maybe two. Why not? And here we are, 17 years later. That grant went away, but other grants came in, and you know how it is. And they kept me around. So foreclosures and I have a rich history together. Um, so what is a foreclosure? I think of it sort of as how a lender sort of repossesses a house, right? A buyer buys the property with a loan, and if they miss paying the loan, the bank, usually the bank, the lender, usually it's the bank, can take possession of the home and foreclose on the loan. Um, it is a lengthy process for all parties involved, and for the tenant, they don't really know about it until a long way into the process. Um, so how does the process start? I guess it sort of starts when the borrower fails to make payments, is when the process starts. After, 4 or 5 missed payments, the lender, the bank, will then schedule what's called a sheriff sale. Um, the sheriff sale is an auction, and the winner of the auction owns the property at the end of what's called the redemption period. So notice of this, I'll get into this more detail, of course, but this is when the tenant usually finds out about it, is when the sheriff sale is scheduled. The tenant is the occupant of the premises, is served with the notice of the sheriff sale. Usually that's 4 to 6 weeks before the sheriff sale happens. Again, the sheriff sale is an auction. Anybody can attend the auction. Anybody can bid on the property, but you need to have either cash, a cashier's check, or proof that you are the lender. I've been to one of these auctions. It's not exciting. There's nobody in like a big hat talking real fast with a gavel, right? It's like a deputy, and there's like a process server there who's got the documents for the bank, and that's really pretty much it. But anybody can bid on the property, cash or cashier's check or proof of the lender. The winner of that auction wins ownership and possession of the property at the end of the redemption period. In Minnesota, the redemption period follows the sheriff sale. In other jurisdictions, the redemption period might happen before the sheriff sale, but here is a little strange. The sheriff sale happens, then the redemption period, typically 6 months, lasts, and during that 6 months, the borrower still retains possession of the premises. They still have the right to occupy the property. If they're a homeowner and they live there, they have the right to occupy through the redemption period. What is renting but selling the right to occupy the premises? So the borrower has the right to continue renting. Basically, the lease stays the lease during the redemption period. It's typically 6 months long, and it really represents the borrower's last chance to save the property. If they come up with the winning bid amount, if they can match the winning bid, they redeem the property, they stay, the mortgage is paid off over, and they live there. They can't, at the end of the 6 month period, the lender takes over and the lender is the new owner. During this 6 month period, the lease is still the lease. The tenant still owes rent. The landlord still owes the duties of repair. If you're in the middle of a year lease, still binding on all parties. If you are a month-to-month lease, you can give your notice and go. It's really weird to say the sheriff sale happened. The landlord doesn't own the property anymore. yeah, they sort of own it, right? They like kind of own it. For like 6 months, they mostly own it, which is really sort of how ownership is in a bunch of weird ways. So that's really the key, is that the lease remains the lease, and the duties the duties still go both ways. At the end, what happens at the end of the redemption? At the end of the redemption period, the bank is the new owner. They have a right to give the tenant a notice to vacate. Month-to-month tenants are entitled to a 90-day notice to vacate. If you've got a bona fide tenancy, if you've got a lease that extends beyond the redemption period, the bank has to honor that lease so long as it is a bona fide tenancy, that the lease is for roughly the fair market value of rent. The landlord and the tenant are not like a parent, child, sibling, spouse situation. And the lease is not some sort of a sweetheart deal. It's a result of an arm's length transaction, not some sort of, buddy deal to defraud the bank. Those conditions are present. The bank has to honor that contract unless, and again, here's the exception and the caveat to the exception, unless they sell the property to an owner occupant. That owner occupant can then give the tenant a 90-day notice. So that's what we're looking at here, is basically a 90-day notice from the bank. Here's the timeline, which is interesting because most leases will be for a year. The process, as you can see, takes a very long time. If the tenant gets the notice of a sheriff's sale on January 1st, and 4 to 6 weeks later puts us at February 1st, right? The redemption period then runs for 6 months. So August 1st, 90 days from there is November 1st would be the last day of the tenant's sort of tenancy. Again, the 90 days, it doesn't start until it starts, right? Until the bank gives it, that's when it starts. Usually there's a lag there. Usually it's more like the 6 weeks, sometimes 6 to 8 weeks for the sheriff's sale. It is a process that can really stretch itself out. And I don't see a lot of homes being saved from foreclosure. This is sort of when I talk to tenants whose landlords are in foreclosure, it's sort of here's what's going to happen and here's roughly when it will happen. And so plan accordingly. That's usually what my advice is. And that's foreclosures.
All right. Well, there are, I guess, probably not shockingly, no questions that have come through about foreclosures. I said this was a bigger issue, 15 years ago at this point.
It would have been, 15, 16.
Yeah, but that doesn't mean it doesn't still happen, and we still get these questions.
We do get these questions, and hopefully it doesn't happen again.
Yeah. So just because we've got a minute here and I want to let folks know we are going to be taking a lunch break from noon to 12:30. We will start back in at 12:30 with the ending of the lease. So we've kind of gone through the process of beginning a lease and what to do with the lease and the tenancy, and then kind of all of the things that come along with that existing tenancy. And then we'll talk about at the end of it how that tenancy can end in myriad of ways. Welcome back to the afternoon portion of our CLE on tenant landlord law, giving an overview. We are going to jump right in with our our managing attorney, Mike, who will be talking about ending the lease. So before this, we were talking about what happens during the tenancy or creating the tenancy. And now we're going to be talking about what happens when you are ending that tenancy. So Mike, take it away.
Thanks, Rachel. Go ahead and send us on to the next slide, please. Okay, so we're going to talk about the 3 most common ways leases get ended over the next 15 minutes or so. In Minnesota, we have the lease term ending, where there's no renewal required by either side. There's a notice of non-renewal by one party or the other, either the landlord or the tenant. The tenant decides to break the lease early, and the other one that happens is evictions, but that's going to be covered at great length later on today. Let's dive into the first one of these topics. Go ahead and go on to the next slide. Thanks. So if we're talking about a basic lease in general, a private market lease, no subsidy involved, between a landlord and a tenant, there's generally No reason that the tenant needs to give to end the lease. If the lease is over, they can simply say, I don't want to do another lease. In general, that same rule applies to landlords. They're allowed to say, I'd rather not do another lease with you. I'm going to non-renew or give a notice to vacate, notice to quit. Those are all sort of interchangeably used terms in this situation. And that's the general rule. The landlord can say, I simply don't want to renew the lease with the tenant. Now, that's not really what landlords do. Turnover is an enemy in general for landlords. They will lose money on turnover. Industry experts claim that landlords lose about a month's rent when a place turns over. So I think it's really exceptionally rare for a landlord truly to have no reason to not renew a tenancy. It might be a very innocent reason. Maybe the landlord wants to move back into their rental unit that they had rented out for family reasons, or they want to sell the place, purely a business reason. All kinds of reasons why a landlord might want to not renew a lease that have very little to do with the tenant themselves, but most of them have something to do with the tenant. The landlord's tired of the tenant being late with rent, for instance, is a really common issue that landlords will cite as the actual reason for not renewing a lease. There are some exceptions to this. This concept that the landlord doesn't need to give a reason for not renewing a lease. The exceptions you see on the screen: public housing, project-based Section 8, Section 42 housing, those are all types of subsidies, housing subsidies, or in manufactured home settings are where you will see the exceptions to that. Also, in Brooklyn Center, a city which has passed a just cause protection in place that protects tenants from sort of arbitrary notices to vacate. What a landlord, however, cannot do is give a notice to vacate for a retaliatory reason or for a discriminatory reason. So retaliation would most likely be something like contacting a city inspector or having filed a rent escrow, which Matt talked about before lunch, or an emergency tenant remedies action. Discrimination, the topics that we heard at the very outset of the start today, any kind of protected class reason for not renewing a lease. We don't see that very often. However, if there's a change in management, then it becomes a little more possible. How I always think about this is if you have, let's say, a racist landlord, they're probably not going to let somebody move in at the beginning who they don't think is the right race. And so it's surprising that they'd shift between the beginning of the tenancy and the end. But if there's a change in management, discrimination becomes a bit more of a potential issue, or maybe the tenant has friends, relatives that are coming over that, again, might be wrong race, wrong religion, whatever in the landlord's mind, and that is the real impetus for the non-renewal. So a landlord's not allowed to do those things to non-renew for retaliation or for discrimination. Next slide, please. A little bit about the logistics of a notice to vacate. They have to be properly timed and in writing. If I'm just naming the two big things that have to happen, assuming the lease requires some notice, which most Minnesota leases do, it's got to be whatever the lease requires is going to be the general rule. If it's a month-to-month or a periodic lease, month-to-month lease is the most common periodic lease versus a term lease, which is usually something like a year or 2 years, then the proper amount of notice to be given is a full rental period and a day is the phrase people like to use. If you could go to the next slide, I like the diagram better for this. So if we're in the middle of April 15th, just picture that being the date. If a tenant is paying their rent normally on the first of the month, which most tenants do, that's when it's due, and the tenant wants to move out as soon as they can, and it's a pure month-to-month lease, that's all that's required is a month's notice. The tenant can tell the landlord on April 15th, I'm going to leave by May 31, not May 15, which is a full month, but it's a full rental period's notice that's required. And the rental period begins at midnight on May 1st and ends at 11:59 on May 31st. So the notice has to be given before May 1st to be effective for the last day of May. Once we roll over into May, it's May 1st, then it's too late to give notice for the end of May at that point. That would be notice effective for the end of June. That's how proper notice is given, whether it's from the landlord to the tenant or from the tenant to the landlord. All right, let's go on to the automatic renewal slide if we could. All right, so the automatic renewal issue is one that is complicated, and wow, if those of you that are struggling to stay awake with a guy speaking with a monotone right after lunch, this is going to be the real test for you here. Automatic renewals it's a thick area of the law. It's governed by a statute that's been around since the early 1970s, which hasn't really meaningfully changed since then. And the concept here is as follows. If we have a lease that the original term was 2 months or more, which is, let's just use a 1-year lease, and there's an automatic renewal that occurs at the end of the lease unless a tenant gives a notice to vacate of 2 months or more, then this statute becomes active. It becomes triggered. Let's move on to the next slide because it's easier for me to just walk through it with a diagram here. We're going to use the calendar year. December 1 is the start, January 31 is the start, December 31 is the end. And the lease requires a 2-month notice to vacate. Pretty common in term leases here in Minnesota. So what that means is the tenant needs to tell the landlord in writing by Halloween, October 31, that they're moving out on December 31. If the tenant does not, what the lease will typically say is that the lease is extended for another notice period. It might say that it's a month-to-month lease going forward, but still with that 2-month notice requirement. So effectively, it is a 2-month automatic renewal of the lease. If that's the case, if we have at least 2-month lease to begin with and at least a 2-month renewal, then this statute becomes active. Now, what's required if the statute is active? If you could go back one slide, Rachel. Sorry about the misdirection there. If the statute becomes active, that means that the landlord is allowed to do this. They're allowed to require the automatic renewal. However, they have to warn the tenant in the right way and at the right time. Not easy to do, and in truth, very few landlords do this right. I would guess it's about 1% of landlords that follow this rule correctly. I believe that landlords have decided they'd simply prefer to ignore this rule and act as if it doesn't exist, but it does. It's on the books and it's been there for 50 plus years, and landlords need to comply with it. So how do they comply? If they wanted to comply, wanted to follow the rules, well, they have to give this warning to tenants. They usually do this, and they have to give it at the right time. With our 1-year period, again, we had December 31 being the end of the year, the landlord would have to warn the tenant between October 2nd and 16th, the real specific 15-day window, about the coming requirement of the notice to vacate. And if they don't do that, then the argument the tenant has is that the lease simply ends on December 31. So that's the time window, that 15-day window. In our example, October 2nd to October 16th. The other thing, and the landlords generally get this part right, that they warn the tenant. But what they don't get right is how they warn the tenant. There's only 2 allowable ways to do this in the state law. Number 1, personal service, or served personally, I think is the phrasing in the statute. Yeah, served personally. What that means is, if you think about that word, personally, it's got the word person built into it. And that's what it's referring to. One person handing it to another. Okay. The other way a landlord can give this notice to the tenant is by sending it certified mail. Certified mail is different than most regular mail. You have to sign for certified mail. Certified mail existed in the early 70s. It really hasn't changed much since then. So it's hard to argue that the legislature meant something other than what it is today. Certified mail is what it was. Those are the only 2 ways a landlord can send this notice. Now, many of them like to send emails these days, or even texts, or slide something under the door. That's not complying with the statute. And this statute starts off with the word notwithstanding the provisions of any residential lease. It doesn't matter what the lease says. It says it right there at the beginning. These are the rules landlords have to follow. The theory is that tenants aren't sitting at home every night reading their lease, wondering what they need to do to comply. If I sign a 1-year lease, it's somewhat logical for me to think I've signed a 1-year contract, not a 14-month contract if I don't take any steps. That's the theory. See a question that popped up. What if the landlord sends it certified and the tenant doesn't pick it up? Well, you know what? The landlord has complied at that point. They have. They've done all they need to do. It's not the tenant's job. I'm sorry, it's not the landlord's job to make sure the tenant picks it up. So, but sending a certified mail, landlords simply don't do. I've seen one or two decent sized landlords in my career that follow this rule religiously using certified mail, but most simply ignore it. And it gives tenants some traction if they miss that deadline that they could potentially use to argue that they shouldn't be held to that automatic renewal that the landlord is trying to use. All right, let's jump ahead 2 slides to lockouts and shutoffs. So a lockout, what we're talking about here, or a utility shutoff, almost always starts with the tenant not paying the rent. The tenant owes the rent, the tenant doesn't pay the rent. Matt mentioned earlier the kind of the core 2-piece argument to or construction of a deal between a landlord and a tenant. The tenant is expected to pay their rent. The landlord is expected to provide a place that's in repair. That's really the hallmark of every lease. I get a place to live, you get paid. That's it. If the landlord isn't getting paid, intuitively they might think I should simply change the locks because the tenant isn't paying their portion of the rent or any rent at all. And so since they aren't, I'm going to deny access, or I'm going to turn off their heat in January, or turn off their water supply, or turn off the electricity. All of those things, go ahead and slide on to the next slide if you could, Rachel. All of those things are misdemeanors. Actually, it's a crime for a landlord to do it. And there's really significant civil penalties as well. $500 or 3 times whatever the tenant incurs for expenses. And having done this a long time, lockouts tend to happen on Fridays. And the court might not get to it till Monday. And so the tenant has to stay in a hotel Friday night, Saturday, Sunday. They have to eat at restaurants because they can't cook. They maybe had to buy the kids new socks and underwear. All kinds of expenses. $500 or 3 times the expenses, and that's not it, plus attorney's fees. And so there's a phrase that we use in our office now and again. A lockout is the dumbest thing a landlord can do that landlords still sometimes do. They get threatened a lot. I've seen creative situations in lockouts that landlords try to skirt the rules. I had a tenant call me once saying that they were effectively locked out of their place. I called the landlord and I said, my client says that you've locked them out, change the locks. And the landlord said, I did not change the locks. That's untrue. And I said, well, are they able to access their unit? He says, absolutely. They can come and go as they please. And I said, but you didn't change the locks. He says, I'm looking at the locks right now. I took the door off and it's in my office and it's the same lock as before. That's actually covered explicitly in the statute. Removal of the door is viewed the same as changing the locks. So something landlords shouldn't be doing, occasionally still do, and there's really big penalties if they do any of this. Okay, that was not easy to do in 15 minutes.
But you did it.
I did
So
it.
well done.
All right.
We had a really quick question before you switch over. Since you had just cause in your portion, obviously Brooklyn Center has that. Is there any kind of talk about expanding that out to the rest of the state?
Well, I think it's possible. I'm not sure how possible it is this legislative session. I think it's possible for other cities to also enact what Brooklyn Center has enacted. So we'll have to wait and see is the short answer. Tenant rights tend to trend towards tenants when it comes to the law because landlords write leases that favor themselves and the law just tries to catch up. And so I think this is something that's probably, I don't know if it's inevitable, but it feels like it might be the way that we go. If a landlord files an eviction, the tenant defends it, the landlord's maybe going to have to come up with a decent reason for retaliation or discrimination anyway. So in those cases, just cause is kind of required in an unspoken way as well. But just cause requires the landlord to upfront say, the example I gave earlier, the tenant was late with their rent several times during the lease. They'd have to say that in advance, that that's the reason I'm giving the non-renewal.
Okay, thank you so much for that.
Of course.
All right. We are going to shift over now to what happens when you need to break the lease. So breaking the lease is when the lease ends often without much notice or maybe in the middle of the term. So I'm going to turn it over to Samuel. So thank you very much, Samuel.
Hello.
And I can hear you.
That's great. All right, so my name is Samuel Spade. I'm a housing attorney here at Homeline and Homeline's Research and Impact Litigation Director. And I'm going to be talking, as Rachel said, about breaking the lease. And here we're really talking about the tenant wanting to terminate the lease early. The landlord wants to terminate the lease early. Normally they're talking about evictions, and that's going to be covered later. So we're going to be talking about the tenant wanting to terminate the lease before the actual end of the lease. So first, the landlord cannot force the tenant to stay, so the tenant can always leave. The only real question is the tenant going to be liable for money? Are they going to owe the rent or some other thing for the rest of the lease term if they're leaving 6 months into a 1-year lease or something like that? There are a couple ways for a tenant to end the lease early without penalty. They are mutual terminations, court orders, domestic violence, illness, death, constructive eviction, military deployment. And we're going to go through each one of them and what happens if the tenant decides to leave without one of these. Next slide. So a mutual termination. Leases are contracts. Contracts can be modified by the parties. So this is one of the most common ways to terminate a lease early. All parties agree to end a lease early, usually on a specific date. And as long as everyone does that, that's good. Doesn't need to be in writing. Obviously, a very good idea to put contract modifications in writing. So we generally have tenants, if we're the ones advising them, try to get that in writing in some way. But verbal agreements will be sufficient. Text agreements will be sufficient. Email correspondence will be sufficient, so long as you meet the standard things you need to modify a contract. You get agreement on all the relevant parties and everyone agrees to it. We'll talk a bit more about what happens if the tenant doesn't agree or leaves without an agreement, but normally mutual terminations happen for a couple of reasons. Number one, maybe the landlord gets fed up with the tenant for some reason. They don't think they can win an eviction, or maybe they just don't want to file an eviction and they don't want to wait for the lease to actually end, so they ask the tenant to leave. But just as often, in fact, probably more often, the tenant gets fed up with the landlord for some reason. The most common reason tenants want to break their lease early is repairs. So we already had the portion on repairs. We very frequently get questions, hey, the landlord isn't making repairs. Can I terminate my lease early? Generally, and we'll talk a bit more about ways that a tenant can do that or force a landlord to do it down the road. But often, if it's not a very significant repair, the answer is no, but the tenant might have some leverage where they can say to the landlord, essentially, if you don't agree to let me out of the lease early, I'm going to sue you. I'm going to file the rent escrow that we talked about. And so the landlord might agree to terminate the lease early. Often, though, the tenant doesn't have a lot of leverage. They just need to move. Maybe they're buying a house. Maybe they're changing jobs. Maybe they're going to school and they're moving out or something like that. And then the landlord and the tenant need to come to an agreement about what's going to happen. Probably the most common mutual termination is the tenant gives 1 to 2 months notice and pays a fee equal to 1 or 2 months. So the tenant says, now I'm going to move out at the end of June, and I'll give you a fee equal to essentially paying rent through July or August. That fully terminates the tenant's lease. If the landlord can re-rent quickly, they actually benefit in a sense, because now they get the fee, essentially additional rent. They get a double collect rent. And if it takes them a month or two, they'll break even. And if it takes them 3 to 4 months, then they start losing out. But the landlord is basically betting that they can re-rent quickly, and it will be a good deal for them. Next slide. Some leases may in fact even include break lease clauses, just like the one I talked about. These aren't super common, but they do exist in some leases. The NAA lease has a place where you can put it in, and that's a very common lease right now in Minnesota. And landlords can put it in. Sometimes tenants will ask for them to be put in. So the lease itself might have a clause. And again, if the lease has a clause, it's probably going to be along the lines of what I just said. It's going to say pay X amount of money, give X amount of notice, and then you can terminate the lease. Again, most commonly 1 or 2 months with a fee of 1 or 2 months. There's really no difference between this and the mutual agreement that we just talked about, but this is sort of built into the contract. So the tenant can just look at the lease and say, all right, this is what I need to do if I want to terminate early. Next slide. And sort of another subcategory of mutual termination is subleasing. By default, a tenant is actually allowed to sublet or assign, so rent to someone else or fully transfer their contract to someone else, if the lease doesn't say they're not allowed to. However, virtually every lease, like it's more than 99.99%, the amount of leases I've seen where subletting or signing is actually allowed or not prohibited is very, very small. So it's almost always prohibited, which basically means that it needs the landlord's approval. But often this is another way to get to that mutual termination. The tenant says, all right, let me find a tenant to replace me for all or a portion of the lease. And as long as the landlord agrees to that, that will work. Normally with subleasing, what you're talking about is the tenant finding a replacement tenant where that replacement tenant actually goes through the standard application process and signs a lease with the landlord. This is not technically subleasing, but it's generally colloquially called that. But once in a while, you do actually have a true sublease or even a true assignment where the tenant finds the replacement tenant and actually signs a lease with that replacement tenant, effectively making them that tenant's landlord. So the landlord rents to A rents to B, and you have hopefully, the rest of the lease covered that way. Again, is allowed, but if the lease says the landlord's approval is required, and the vast majority of leases do, then the tenant has to get the landlord's approval before doing that. Next slide. So court order. This is possible. Tenants can often get the lease terminated by court order. Obviously, the landlord can too. That's evictions, and that'll be coming up. But the tenant can also sometimes get the court to order the lease to be terminated. The primary way for a tenant to do this is through either a rent escrow or an ETRA. You can also technically get them through TRAs or tenant remedies actions. You can get them through lockout petitions as well. But again, the vast majority of lease recessions are done through rent escrows or emergency tenant remedies actions, ETRAs. The court specifically has authority to terminate the lease in both of these cases. However, the court's authority to do that is discretionary. So to just go through a sample scenario here, let's say that there are repair issues. The tenant files a rent escrow, so they give the 14-day notice, or they get the city inspector out there, they wait for the deadline to pass, they file a rent escrow, and what the tenant asks for is, judge, order the landlord to fix the problems, maybe give me some rent abatement back, and terminate my lease. Sometimes if it's bad enough, they even skip the first two things. They just say, all I want is my lease to be terminated. The court can certainly terminate the lease here. And we do actually see courts do this. So this is one way if a tenant calls us, and again, most common reason tenant wants to break their lease is unmade repairs. Tenant calls us, says, we want to get out of our lease because, there are roaches, or we want out of our lease because the water is not there's not a lot of water pressure or something like that. Maybe not bad enough where the building is going to get condemned. We'll talk about that in a moment, but bad enough that the tenant no longer enjoys living there. And what we'll say is, all right, go through the repair process, send that 14-day letter, get the city inspector out there, get an order for the landlord to fix the problems, or wait that 14 days, file the rent escrow. And then when you file that rent escrow, ask the court to terminate the lease. And it is at the judge's discretion. The tenant cannot force this. But if the problems are bad, especially if the landlord has shown that they're not really willing to make repairs, judges are pretty willing to terminate the lease. So court order, a very viable way for a tenant to get out of their lease, so long as they have a way to actually get into court. And that's really the thing, is can the tenant find some reason to get in front of a judge? Like if all the tenant wants to do is move because they've taken a job somewhere else, there's no way for them to get into court on that, and a judge is not going to simply break the lease in that case. So they've got to have a way to get into court in the first place. All of that said, these are still fairly rare, because if you think about the amount of tenants that actually file rent escrows or ETRAs, it's not a very high percentage of tenants. But if it gets bad enough for a tenant to get to that point where they're going to court, this is a fairly realistic option for the tenant. Next slide. Victims of violence or domestic violence, tenants are allowed to break their lease in these situations. Now, they have to be a victim of certain things. The statute says domestic violence, criminal sexual conduct, sexual extortion, and harassment. And all of these are words that have legal definitions that the tenant has to meet. So it's not just any type of violence. It has to fit within the category. Now, a lot of these categories are pretty broad. Domestic violence and harassment cover a very, very wide range of things. So if a tenant is being harassed, there's a pretty solid chance that they will fit into one of these categories, but they do have to fit into one of these statutorily defined categories. They also have to have an imminent fear for their safety. Now, in practice, this is generally assumed. If someone is being harassed or they're a victim of domestic violence, they have an imminent fear for their safety. The only time this one really comes up is if like something happened 4 years ago and they're trying to use that as a reason. They have to point to some reason why it's now an issue again. But again, most of the time, if they're a victim of domestic violence or any type of violence, they have a fear for their safety. So that one's going to be just met kind of by default. The next thing they have to have, though, is they have to have a qualified document. There's a bunch of different things that qualify. Restraining orders, orders for protections are sort of the gold standard. Harassment orders, a statement from a sexual abuse counselor that complies with specific wording in the statute will work. Statements from law enforcement officials. There are a bunch of different things that will work, but the tenant does need that document. They need a document that qualifies, which again requires them to take some step. It's not a document that they can create. All of these documents you can see they're from the court, they're from law enforcement, they're from, again, a sexual abuse counselor. So the tenant has to take some steps to go get this document. But if they can get that document and they meet the requirements, they can give the landlord a notice that says they have fear for their safety. They want to terminate the lease. They get to pick the date. They get to pick any date they want, the day of or in the future, where their lease is terminated. So they can say, all right, I want to terminate my lease today, May 8th. I want to terminate my lease May 10th. I want to terminate my lease, June 15th. Now, the farther out in the future, if the tenant's saying, I want to terminate my lease 3 months from now, you might have a question about whether they actually have an imminent fear. So that's pretty rare. Normally, if a tenant wants to break their lease, they're picking a date pretty close to the time they're sending the notice, at most maybe a month out. They still owe rent for the full month. So if they give a notice today for May 10th, the lease is over May 10th, but they owe the full rent for May. If they pick, June 2nd, they owe the full rent for June. So normally we try to get tenants to pick a date, that doesn't go to the first or second of a month unless they have no other choice, because they don't want to owe that full rent if they're only there for a day or two. So we try to get tenants to really get a date before the end of the month. They do owe full rent for that month. They also forfeit their deposits. This is unfortunate for the tenant, but there's been back and forth in the legislature about this, and it stays part of the law. They forfeit their deposit. This is essentially the penalty. I shouldn't even say penalty, but it comes across as a penalty. This is sort of the compensation to the landlord, because the landlord's not normally at fault here. In fact, I should just say the landlord's not at fault here. If the landlord was at fault, there'd be other things that the tenant could do if the landlord was the one harassing the tenant. So the landlord's not at fault here. So this is what the landlord gets to keep sort of as compensation for the fact that the tenant gets to just walk out of a contract. The lease also ends for all remaining tenants on the lease. So if the tenant is not the only tenant there, and often they're not, because often, especially with domestic violence, the other person is the problem, that lease is over for everyone. The lease just terminates. The landlord certainly could re-sign a lease with anyone who stays if they wanted to, and sometimes you do see this. But in theory, everyone should be moving out if the landlord doesn't sign a new lease with the remaining tenants. That is just, the lease is over, everyone leaves. Now, very important, this does terminate the lease. If the landlord tries to come after the tenant for penalties here, they're coming after the tenant for things that the tenant does not owe. If they're reporting debts to credit agencies or giving the tenant a bad reference, the landlord can open themselves up to liability for reporting false debts. Any debt collector that tried to collect these opens themselves up for liabilities. I know this is really for landlords and tenants, but if debt collectors are trying to collect this when the tenant officially terminated their lease, that's a big problem for them. And there's also one other thing that a landlord is required to do. They cannot disclose any of the information that the tenant gives to the landlord to get out of the lease. They can't disclose that to other landlords, to the abuser. And if they do, there's a penalty. The landlord who violates that section is liable for statutory damages of $2,000 plus reasonable attorney's fees and costs. So any landlord who is disclosing this information puts a big target on their back that the tenant will effectively be able to sue them for. And there's not really that much the tenant needs to prove other than the landlord disclosed it. So this is something the landlord should be very cautious about. If they get this and they have any questions, they should obviously consult an attorney. But in general, this lets tenants out of their rights. For people who are working with tenants, um, Law Help MN, which is just lawhelpmn.org, has a very good article, webpage with additional information that has a form letter the tenant can use to break their lease, that has the statements by qualified third parties as part of their lease, that has sort of a step-by-step checklist that the tenant can go through what the tenant needs to do. I use this myself when talking with tenants. I refer tenants to it. And also Law Help MN has links to other things that tenants might want access to, like day one services or other social safety nets for people who are experiencing domestic violence. All right, next slide. Although actually it looks like there might be a question here. Yes. So say the household flees violence and goes out of state, leaving the items in the home. Can the landlord seek additional funds for the disposal of items left behind? So this is a bit of a question here. The letter that the tenant has to send, so there's a notice that they have to send, they have to say what they want the landlord to do with the property. Under state law, by default, the landlord has to store the property for 28 days. So if the tenant says, store my property, then it will default to state law. The landlord has to store the property for 28 days. They can charge the tenant reasonable storage fees for this, but they've got to store the property. Otherwise, a lot of times tenants will just say, throw everything away. And in this, yes, the landlord might have a claim for damages for throwing the property away. It does have to be reasonable. We get a lot of people in Minneapolis who are like charging their tenants for trash pickup when Minneapolis, it depends on where you live, but often it's very generous trash pickup. And I live in Minneapolis, I know this, and it's like, why are you charging the tenant for something the city is doing for free? So, I mean, these have to be actual causes, but yes, if the tenant leaves, if there's damages, if there's debts prior to the tenant left, so this doesn't wipe out the tenant owing money before they left. Again, in this example, let's say they leave in May, they owe May's rent, but they haven't paid May's rent or April's rent. Those debts still exist. So it doesn't wipe out debts prior to the tenant's leave. It just wipes out all liability after the lease is over. All right, so VAWA, Violence Against Women's Act also applies to men. Really only applies to people in subsidized housing. So there's a bunch of different types of government subsidies, but it protects federally subsidized tenants from a variety of different things, mostly things like evictions and that type of thing, but it can also be used in some cases for the tenant to transfer from one unit to another. Again, if they're in like public housing or project-based Section 8, they have a right to ask for an emergency transfer. The PHAs or public housing authorities are supposed to have a plan set up for how to do this. And so they have a right to move from one unit to another. If they have a Section 8 voucher, they have a right to port their voucher essentially, because normally with a Section 8 voucher, you've got to be there for 1 year, you've got to give proper notice, et cetera, before they won't take the voucher and transfer it from unit A to unit B. But with VAWA, the tenant has a right to port the voucher. It also allows for bifurcation of the lease. So basically separate out the lease. So if the abuser is one of the other people on the lease, they can be removed while the tenant stays. VAWAs, it can be fairly complicated because it gets into subsidized housing, and again, you're dealing with public housing authorities, PHAs, and their things and stuff like that. So it gets fairly complicated and can depend on where you are. But in general, it will also protect the tenant and maybe even allow them to terminate their lease. Next slide. All right, illness. So it says illness, really it's the tenant needs to leave early because they need to move to a medical facility. This one is pretty specific. It's covered by state law. You can see the statute down there, 504B.266. They have to give a 2-month notice. It has to be determined by a medical professional that they need to move. And it's only an option if they are moving to a medical facility. It's not just that something happened and now their unit is a bit harder to live in, unfortunately. They've got to be moving to a medical facility. There's a bunch of different things that qualify as a medical facility, but you have to refer to the statute to see if it would. And it will terminate the lease for everyone, but the landlord could agree to extend the lease for tenants who are still living there, because there might be other tenants who don't need to move, but it does terminate the lease. Next slide. Constructive eviction. This is another big one. Again, vast majority of people, tenants who want to break their lease, want to do so because of repairs. So they contact us and they say, there's mold, can we break our lease? There's roaches, etc. The short answer is a tenant can break their lease if there are repair issues, but only if the building is destroyed or becomes uninhabitable or unfit for occupancy through no fault or neglect of the tenant. This is a pretty big standard. On the one hand, you have condemned or burned to the ground. Clearly this works. The building can't be lived in. On the other hand, you have a broken window. Clearly not unlivable. A problem can force the landlord to fix it, but not unlivable. Anywhere in between that is sort of the spectrum of other things that you might want to break your lease for if you're the tenant. And maybe you can, maybe you can't. It is a bit risky. We do not normally tell tenants to use constructive eviction unless the problem is really bad. Again, gold standard is condemn. City orders you to leave. If the tenant wants to do this, they should hand over the keys, remove all their things, give the landlord a letter stating that the lease is terminated because it is unlivable, and just move out. If they're saying it's unlivable, they shouldn't be living there. I mean, there's some leeway on this. The courts are going to understand that you can't, like, sometimes a bad place is better than being homeless. So it doesn't mean tenants have to move out, you know, day one of a serious problem. But if a tenant's been there for 5 months, probably it's not unlivable. Unlivable, you got to be bad enough that you really need to move. Then what happens is the landlord sues the tenant for non-payment of rent or refuses to give the tenant their security deposit back, and the tenant sues the landlord, and it goes in front of a judge or possibly a jury in some rare cases, and the trier of fact decides. If the tenant wins, they get their deposit back. They might get rent abatement, other things like that. If the landlord wins, they get rent until they re-rent it. So it's very risky for the tenant to assert this, again, unless it's very clear that the place is unlivable. We do not normally recommend it. We recommend tenants file rent escrows, that type of thing, rather than just breaking their lease. Try to get that court order I discussed earlier. But it is possible and can be used in some cases. Next slide. Death of the tenants. This, fortunately, is not something we get a lot of calls about. But if all the tenants die, and it does have to be all of them, so if there's more than one, it would have to be both. But if all the tenants die, either the landlord or the tenant's personal representative may terminate the lease with 2 months' notice, effective the last day of the month, hand-delivered or mailed notice. Otherwise, the lease continues. Death doesn't always terminate contracts. It does here, but it's got to be at the landlord's or tenant's request. They got to send that notice, and it does take 2 months. So again, you know, most tenants might have something of an estate, but probably not enough to sue over. But it is 2 months of rent that they would need to pay or the estate would need to cover. Also important, though, to understand that during that 2 months, the lease is ongoing. So if there is a personal representative or someone who can act as the tenant, that person gets to come and go from the apartment, has a right to act as the tenant. The lease is still effective. Obviously, and in many cases, this is what happens. The tenant and landlord can decide to terminate even less. Maybe all the properties out and the landlord just wants to re-rent or something like that. As the slide said, it relieves the estate of rent liability, but not damage claims if there are existing damage or something up to that point. Next slide. Military deployment. We don't deal a lot with this. It is federal law, though. If there is a military service member, they need to move because of deployment or something, they can give 30-day notice. It terminates the lease for them and their dependents. There's not really much a landlord can do. Also, you can't generally sue people in the military. So, you know, frankly, if someone is in the military and they need to get up and move for the deployment, they're out of the lease. Again, we don't see this one very often. And often if it does come up, you know, the military service are probably members are talking to their attorneys that they have in the military who are then representing them or sending these types of notices to the landlord, but does let them out of their lease. Next slide. All right, so let's assume that none of the above apply and the tenant simply needs to leave for one reason or another, and they just walk out. 6 months into a 1-year lease, there's 6 months left, or, you know, month to month, they just leave without notice. If the tenant abandons the rental dwelling mid-lease, the landlord must make reasonable efforts to re-rent the place. They have to try to mitigate the damages. So they have to try to find another tenant. If they don't find another tenant, then, if they don't find another tenant, they can continue to charge the tenant through the end of the lease, but they are now capped. It's basically assumed when the tenant abandons the rental property that they gave a valid notice, whatever that would be. So 6 months into a 1-year lease, it's assumed that they gave a notice for the end of that 1 year. That's as much as the tenant can be liable for. Month-to-month lease that requires 2 months notice, it's assumed that they gave a 2-month notice. So if the tenant abandoned the property today, they could be charged through the end of July. Again, assuming a 2-month notice. Assuming a 1-month notice, they could be charged through the end of June. Landlord has an obligation, like I said, to re-rent. If they do re-rent, they're off the hook. The tenant's liability ends. If they don't try, if the landlord does not try to re-rent, they're also probably off the hook. This gets into, duty to mitigate, et cetera, and what happens there. But if the landlord is not trying, the tenant has a real chance of arguing, hey, you didn't try to mitigate the damages. If you had, you could have found a tenant. So we're going to treat it like you had. Now, this is something that would have to be decided by a court case or by a judge in a court case, but it gives the tenant, again, some leverage if the landlord just sits on their hands and does nothing. The landlord has an obligation to try to find a new tenant. Next slide. So last, break lease fees. So like I said, sort of at the start, what the tenant is liable for is the rent until the lease is over or until the landlord re-rents. As we just discussed, landlord has a duty to try to mitigate, try to re-rent. So that's actual damages. Not to get too technical here, but actual damages in the law are damages that have actually accrued. So the rent, tenant's supposed to be paying rent, landlord's not getting rent. Those are actual damages. That's the primary thing that a tenant owes if they break their lease. Lots of leases, though, and this one is pretty common, lots of leases like to have a break lease penalty. If you break your lease, you owe us $1,000. If you break your lease, you owe us $2,000, and you owe all of the rent. The NAA lease has this language in it, I believe, and there are other leases that have it as well. It's pretty common. These break lease fees are liquidated damages. That's the legal term for it. And the short answer is they are almost always going to be unenforceable. There's a recent case, I mean, this has been true essentially forever, but there was a recent case that discussed this very specific issue as it relates to leases in 2023, Lagoon Partners v. Silver Cinemas. Not a residential tenancy, but the law would be the same here in either case. And the lease had this break lease fee. The lease said you pay, I don't remember what it was. It was a lot of money actually, because again, this is a commercial building. Commercial rental, you pay this money if you leave. The tenants left early. The landlord had actual damages. They had damages in the amount that the tenant wasn't paying in rent, and the court awarded them that. The court said, look, you get actual damages. The tenant's not paying rent. This is the amount that you're harmed. You get actual damages. But the court looked at the break lease fee and says, this is unenforceable. I'm not going to go into all the details of what you need to have liquidated damages. In general, you can't get liquidated damages if you can get actual damages. And since you can always pretty much get actual damages in a break lease, liquidated damages are just out. But more importantly, they have to be reasonable and they can't be punitive. And almost all break lease fees are. Again, if you think about it, you owe $1,000 if you break a lease. I mean, that's just a penalty. The tenant already owes the rent. The $1,000 is just essentially a punishment. So break lease fees, almost always unenforceable.
Awesome.
And I think that is my final slide.
Yes, it is. I have a really quick clarification question.
Yes.
What is the difference, or is there a difference between like a break lease fee that you're talking about in this slide and say the additional 2 months of rent that a tenant would have to pay on top of, if they're using a break lease term in their lease?
Sure.
Is there a difference?
Yes, that's a great question. I should have talked about it. So the break lease fee that I talked about earlier, and I understand the confusion because we're using the same words, but the break lease fee that I talked about earlier is part of a settlement or a mutual agreement. So the other side is saying, what I'm paying to get out of the lease is this amount of money. And I'm giving it to you, the tenant is giving it to the landlord precisely so that the lease can terminate early. And that's the contract, that's the consideration, that's all of, that's the agreement. So it's going to be enforceable. The break lease penalty is just a term in the lease that says, we're not making a deal. The landlord, I'm just fining you, the tenant, this extra money. That's the liquidated damages, and that's what's not enforceable. Uh, does that work
Yes,
for clarification?
that's
All right.
fantastic. Thank you very much for that. And yeah, it is. Unfortunately, this is kind of the industry has decided that both of those things are called break lease fees, and
Yeah.
it's not an us thing. It's an
Yeah.
industry thing.
And one other short point there. I mean, you might wonder, well, then why would the tenant ever make the deal and pay the break lease fee if they can just leave and these break lease fees are unenforceable? And the answer is, it is a risk. And sometimes we talk to tenants about this. If they live in a place where vacancy rates are super high or super low, and the landlord is almost certainly going to get someone else in immediately, they can roll the dice. They can take on that risk and say, all right, I'm going to leave. You have an obligation to re-rent. You're probably going to re-rent it in a month. That's way better than me giving 2 months notice and paying a fee equal to 2 months. I'm just out of here, re-rent. But the risk that the tenant runs there is that the landlord does not re-rent, and then they're on the hook for many months.
Mhm.
So the tenant pays the break lease fee as part of the deal in order to sort of shift that risk over to the landlord, and the landlord accepts that risk again, because if they think they can re-rent quickly, they actually benefit. They get to collect both the break lease fee and the rent, because it's an agreement, something they cannot normally do. So as long as they re-rent quickly, the landlord benefits.
Awesome. All right. Well, thank you so much, Samuel. I appreciate you and your time here. We're going to switch over into evictions, which is actually the section that I'm going to do today. So one of the things I am a housing attorney here at Homeline, as well as the communications coordinator, which is why I've been coordinating today's CLE, moving slides along. But I also work predominantly in our eviction queue here. So I've got the eviction section of this presentation today. All right, so evictions, kind of a quick history. So before this kind of laws were put in place, there was a issue with what's called self-help. Basically, landlords would show up on, think of it as the Wild West almost. Landlords would show up on their tenants' doorstep and say, "I need you to get out." Point a shotgun at them and say, "You need to leave now." That's for no reason or legitimate reasons, it was all outside of the judicial process and the law. And tenants didn't necessarily have a lot of recourse if the landlord was, say, like retaliating against them or um, didn't have any real grounds for it beyond the fact that they just wanted their property back. So the purpose of an eviction action is to give landlords access to the judicial system so that they can legally remove a tenant from a rental property. So the purpose of an eviction is possession. It's not actually going to get the landlord a money judgment if the money is at issue. It's just going to get them what's called a writ of recovery, which says that they have the right to retake possession of that rental property. At its heart, any eviction action is just going to be a contracts dispute. It's, at least like we've been saying, is just a contract. And so what the eviction action is about is whether that contract has been voided in some way. So in Minnesota, there are kind of four buckets that a landlord can use to file an eviction. Non-payment of rent is by far and large the most common one. So about 90% or so evictions filed in Minnesota are going to have some sort of non-payment of rent issue with it. Something called holding over after a notice or a lease termination has been given. So that's a holding over eviction is when the tenancy has legitimately ended and the tenant is still remaining there. They are no longer a tenant, they no longer have the right of possession, but they are still there. And so holding over is an eviction action as well. Certain illegal activities, as defined under 504B.171. We'll get more into that, but that's going to be specific things like illegal possession of drugs or guns, if there's prostitution, storing illegal, contraband. Otherwise, also material breach of the lease. And we'll get into all of these. So the process in general, it's a summary process, meaning that it goes fairly quickly, right? That's one of the essentially the perks that the judicial system has given to property owners to try and, to reclaim their property is that this is designed to go fast. So once the complaint is filed, a summons is issued. Service has to be done at least 7 days before the court date happens. We've seen in recent years, mostly since 2020 and the COVID-19 pandemic, what the law says is that courts have to have a court date within 14 days of the summons being issued. And so courts, to comply with that, even though their court calendars may be much, much, much too busy to allow for that kind of scheduling, they'll issue a summons after, sometime after the complaint is filed with the court date. And so this isn't consistent throughout the state, but we are seeing that where, say someone landlord files an eviction action on the 15th, and so then the court will actually issue that summons paperwork on the 21st, and the court date then is going to be 2 weeks after the 21st. I have lost my ability to math that off the top of my head, sorry. So that's kind of, there can be a delay in all of that. But what the law says is that once the summons is issued, the court date has to be within 14 days, and that the landlord has to serve the tenant at least 7 days before the scheduled hearing is supposed to happen. Once the hearing happens, it can either result in a settlement or it may go to trial. And if the tenant loses at trial or doesn't comply with the settlement, then the court will issue what's called the writ of recovery. And then the landlord can take that writ of recovery to law enforcement, usually the sheriff, and the sheriff, or excuse me, law enforcement will execute the writ, meaning that they will go through the process of removing the tenant from the property. All of this can go pretty quick. Again, depending a lot on the court schedule, but once the complaint is filed, then say they have that hearing 2 weeks later, and the tenant doesn't succeed at that hearing, then the landlord can get that writ of recovery right away, and then the once the sheriff gets it or once the law enforcement gets it, it usually happens where the tenant is removed within a couple of days of that hearing. So, all right. So we'll move on to specifically service. So service is the process of letting the defendant know that a claim has been filed against them and where and when they can essentially have their day in court, their due process, be able to share their side of the story. There is a very specific service process that goes in with eviction actions. So anyone but the plaintiff can serve. So as long as they're not a party to the action, so that also means like a property manager who is the agent of the landlord can't serve, but like the landlord's best friend probably could. A lot of landlords are going to hire service processing companies to do this for them because it makes it a lot easier. They don't have to worry about it being potentially a problem with service. Substitute service, so that is allowed. Basically, what that means is that whoever is serving can serve the court papers, the summons and the complaint and such, on someone who is of suitable age and discretion who lives at the property. Now, I have certainly had it where like someone serves the babysitter, for example. That is not proper substitute service because the babysitter probably, they don't live there. That's not their permanent home. Also, serving on, say, a small child who, yes, they may live there, but they're probably not of suitable age and discretion. What becomes suitable age and discretion is great question. Someone's 8-year-old, probably not. Someone's 16-year-old, probably yes. But, that's a potential point of subjectivity that could be brought up as a problem with service. Landlords are supposed to attempt personal service, so actual like handing the paperwork to the defendant at least twice before they're allowed to do what's called nail and mail, where they post and mail a copy of it to the tenant's actual door. Now, the law has recently been updated to clarify that that has to be, if they are using a nail and mail, that it has to be to the tenant's actual unit door. It used to be where sometimes, and this was not right then, but still more clearly not right now, that service processors would post it to the front door of the building, right? And that is not a great way of notifying someone that they have to go to court. So it does the statute does specify now that it has to be done to the actual unit door of the tenant. There also is a new obligation that if electronic communication is regularly used between the parties, email, then they also need to notify the tenant via email that this has happened. So the court date and the time and such. And then the landlord has an obligation to file affidavits with the court to show that they have checked all of these boxes and gone through all of these steps. All right. So if complaint, there's some very specific things that the complaint should include, depending on the type of reason that the landlord is filing the eviction for will also dictate what should be included or not. But obviously a detail of who the parties are and the property involved, that's pretty clear. The detail of the alleged breach or violation. Also, those are the two basic things that any complaint needs to have. Copy of the lease, though, if there is a written lease, if there's an oral lease, then obviously it's impossible to include a copy of that in the complaint. But if there is a written lease, then a copy of it should be included in the complaint that's been filed. If it's for a non-payment of rent case, then a ledger detailing all the accounting of how the landlord got to the amount of past due rent that's owed was arrived at, as well as the pre-eviction filing notice. We'll get to that in a second. That is also something that's a requirement for non-payment of rent cases. If it's a holding over case, then they need to include a copy of the notice to vacate that they gave. And then they also need to say whether the tenancy is affected by federal or state subsidy programs, because subsidy programs often have their own rules. We talked about just cause, we talked about notice requirements, all those things. So it's important for the parties to know and for the court to know whether there's a subsidy involved or not. All right, so as promised, pre-eviction filing notices. So at this point, every landlord in the state of Minnesota, if they are going to file an eviction for non-payment of rent, they have to first give the tenant a written notice of their intent to file an eviction for non-payment rent before they can go file. That has to be done at least 14 days before they can go file. That's the state minimum. This notice, though, only applies to non-payment rent cases. So if it's a holding over case, then the landlord does not need to give this notice. Theoretically, the notice to vacate is the notice that they were given. The notice has to include some very specific things. Minnesota statute 504B.321 kind of goes through all these details. But it has to include the total amount due, the specific accounting, so that ledger about how that amount was determined, the name and the address of the person authorized to receive those rents and fees if the tenant is going to pay it, specific language about where a tenant can contact if they're looking for assistance, like with rental assistance help paying the rent, and language saying that the landlord can file an eviction if the rent isn't paid or the tenant doesn't move out within 14 days. So that's another thing as well. This can also function as a note, basically a notice to tenants before an eviction is filed that, hey, the landlord is planning on doing this if you don't pay. And so maybe, at this point, you need to move out, because if you're not going to be able to pay, then you're going to be evicted. It's also important to note that some cities and types of housing have a more than 14-day notice requirement. So subsidized housing, federally subsidized, has a 30-day notice. Section 42 housing has a 30-day notice, but so do some cities. Minneapolis and Brooklyn Center and St. Louis Park all have 30-day notice requirements at this point. So it's important to also know, that's why it's important to figure out, what are the rules in the cities that you're in. All right. So now we'll go into the specific types of eviction cases and some of the defenses and situations that evolve from those specific types. So non-payment rent, like I said, the most common reason why folks are getting evicted. Defenses are that a tenant has what's called the right of redemption. So the right of redemption is if the tenant can pay everything that's due, including the late fees, if they're part of the lease, the past due rent, everything that they owe, plus allowable court costs, or cost of the action, then they can redeem the tenancy. Now, cost of the action is allowed by statute. It's going to be your, usually it's your court filing fee. If they hire a service processor, that fee is often included. And then the statute language actually says up to $5 in attorney's fees. Now, so that's what the landlord is limited to, including for court the cost of the action. Another thing that can be done, this isn't super common anymore, but it's one of the things that if the landlord accepts a partial payment after the eviction has been filed, then there's an argument that they've effectively waived their right to collect on the remaining balance and they can no longer evict. Now, most leases have very specific language that says that no, so you can contract around that part, right? So most leases these days have language that says that the landlord can accept a partial payment and does not waive their ability to continue to collect or evict for the remaining amount. But if the lease doesn't have it, or like it's an oral lease or something like that, then that could be a defense to a non-payment of rent eviction. If there's a dispute over the amount of rent owed, you paid the rent. This is where receipts come in really important. So obviously, there are some methods of payments where it's much easier for the tenant to access proof of payment, like ACH, electronic transactions, or checks, if you're doing it that way. Money orders, though, are almost as ephemeral as cash is, right? Unless you get a receipt from the landlord saying they actually got it, then there's no way that you can prove that the landlord actually got that money in their little hot little hands. So there is a law in Minnesota that says that if a tenant pays for rent in cash, that the landlord has to provide a receipt for that. And a lot of folks I know think that with money orders, you have the receipt because you have the receipt from when you bought the money order, which is great. That proves the existence of the money order, but it does not necessarily prove that the landlord got that money order to them, right? And yes, you can track money orders to see if they were cashed and who cashed them, but that process can take months. And so it is not going to be very effective defense in an eviction action, which, as we said, tend to go very quickly. Fritz defense was talked about earlier with repairs, but if there's a repair issue that the landlord hasn't been using, then this is where you would bring up that Fritz defense to say, I don't owe the landlord money, or at least not all the money that they're claiming I owe because I haven't been getting full value for the rent, right? Improper late fees or improper fees in general, like maintenance fees or if the late fees are above the 8% that are allowed, or if there's no late fee option. Here's the thing, oral leases can't have late fees because you need to have that in writing, right? And so if you have an oral lease, you can't charge a tenant late fees. Improper or no pre-eviction filing notice, the statute is very clear that if the landlord does not give the proper notice, or like they filed the eviction before the 14 days are up or the 30 days are up, or they don't give a pre-eviction filing notice at all, that the case needs to be dismissed and expunged from the record. Okay. Okay, holding over. So holding over, defenses to holding over are a little tougher. It's much more of a cut and dry situation normally. Really, the only defense to that is that the notice was not proper. Either it was short, so say the lease requires one rental period, and the landlord gave notice for on May 1st that they had to be out May 31st. We see that often enough. That is not proper notice, as Mike was talking about earlier. Or the notice wasn't in writing. It needs, the notice should be in writing. You should keep your paper trails. Even if it's a verbal lease, it should still be in writing. And otherwise, the other defense that sometimes comes up is waiver by acceptance of rent. And so, say for example, tenant was supposed to be out by the end of April, but then landlord accepts their rent payment for May. Then that shows that there's a presumption that the tenancy is going to continue on, right? So that is basically voiding out that notice to vacate. All right, what time am I at? All right, let's chug along here. Breach of lease. These are the most complicated ones because this is a pretty subjective. What is material or not material can be very subjective. So defenses to that sort of thing are like, I didn't do it. What the landlord is claiming that I did just didn't happen. Or the lease didn't prohibit what I was doing. So yes, I did do it, but it's not an actual breach of my lease. Not material. Again, that's where this is going to be more complicated, trying to show, yes, I did the thing, but it's not such a big deal that I should be kicked out of my home for it, is essentially what you're trying to convince the judge of. And that is going to be something that you'll have to convince either a judge or a jury or one of those folks about the materiality or immateriality of the breach. Or again, waiver by acceptance of rent. You know, you were told you need to leave, and you didn't, or the landlord continues to accept rent even after they've told you need to get out. All right. Tenants in public housing, specifically, this is a very limited one, but tenants in public housing have the right under Minnesota law to a court-appointed attorney in breach of lease eviction cases. So it's only ones who are in specifically public housing. This doesn't extend out to like Section 8 or Section 42. It's very specific public housing. They have the right to counsel in breach of lease cases. All right, illegal activity. So landlord is bringing a case that you need to be evicted because you have done something illegal under the specific statute. So defenses are, you must have permitted the conduct. Either you didn't do it, what the landlord is claiming that you did, you didn't do, or you didn't know about it. That one's a little harder. Oftentimes it's going to be like if your guest did something illegal, you are often going to be liable for the actions of your guests, like we talked about earlier. But there is an argument to be made that if you didn't know that your guest was using illegal drugs in your bathroom, then maybe that's going to be a defense to this. It's again going to be up to the judge. And then there's also this carve out here as well that a landlord can't evict a tenant for committing a nonviolent crime that happens somewhere else other than the rental property. So like if someone, if someone commits a nonviolent crime, down the block or something like that, then that's not grounds for illegal activity-based eviction action because it didn't happen on the property. There are exceptions to that, of course, but that's going to be the general rule. All right, so like I said, tenants in public housing have the right to counsel in breach of lease eviction cases, but this doesn't impact most tenants. Other defenses that may apply to anyone's illegal discrimination or retaliation. Matt went through that retaliation very thoroughly, and Philip went through this morning on legal discrimination, but those can also be defenses to any eviction case. Okay, so at this point, most eviction cases in the state are being held over Zoom. The exception is going to be for Hennepin County. They have by far the most evictions of any county in the state, and so they're going to be in person at their courthouse. But otherwise, the Supreme Court has issued an order that these eviction hearings, are going to be held remote. There's a high rate of defaults, unfortunately, on these cases. That's a problem. Like tenants are just, they decide that they need to leave, that there's no point in going, and so they don't. And the problem with that is that you'll lose a lot of your opportunity to make any defenses or make a settlement, things like that. Most courts are asking tenants to provide their exhibits ahead of the initial hearing, so they want tenants to upload their exhibits to Minda's before the first hearing happens. And there's a heavy emphasis on settlements. Courts like it when the parties settle, for any case, really. But like a payment plan plus expungement or a move out date plus expungement are pretty common types of settlement agreements. So that is certainly something that happens. It happens on a fairly regular basis. And so, something to consider. All right, so the writ of recovery. What happens if the writ of recovery is issued? So that is the paperwork that, again, says that the landlord has the legal right to kick the tenant out. If the tenant defaults, then they get it. If they lose the trial, the landlord can get it. Or if they have a settlement, but then the tenant doesn't do what they said they would do, then the landlord can file what's called an affidavit of noncompliance and ask for that writ of recovery. So in every case, the court shall stay the writ of recovery up to 7 days, except for when the tenant is either seriously endangering the safety of other residents or they're intentionally and seriously damaging the property, in which case they can um, uh, they can expedite that writ. They don't have to wait those 7 days. So the process of getting that is that the plaintiff, the landlord, requests the writ from the court and the court issues it. The plaintiff takes the writ to the officer, usually it's the sheriff. The officer executes the writ, and then the tenant has 24 hours to vacate from when it's executed, either handed to the tenant or posted on their door. After that 24 hours, then the sheriff can come and remove them and anyone else on the property off at that point. Tenant options are pretty limited after the writ is issued. They can ask for a stay of that writ. That's going to be the court's discretion, whether they're going to grant an additional stay. They can try and negotiate more time with the landlord. The landlord they're the ones steering the boat at this point. So if they're willing to delay in either bringing that writ to the sheriff or even asking the court for it, they can do that. You know, again, this is they're captaining this boat. You can also do a motion for judicial review in some circumstances. So there are a lot, well, not a lot, but there are courts that have a specific housing court, or they'll use a referee instead of a judge for these types of cases. And so if your case is heard by a referee, then and the tenant feels that the referee messed up in some way, then they can ask for a judicial review, to have a judge review it. Now, most of the time, these judicial reviews, the referees know what they're doing. Honestly, the referees often see these cases way more often. They're way more familiar with the law than judges are in many cases. So the judge is, what the referee is, they're going to back up what the referee has decided. The other option potentially is, if there is not an option for judicial review, or there's still like an issue with what the judge has decided, or there's other things that are happening here, there's a Rule 60 motion option as well, or a motion to quash the writ. That's going to be for the standard reasons, mistake, inadvertence, excusable neglect, or fraud. These are rarely granted, these motions to quash. The tenant really has to show, one, that they would they've got a reason why there was an issue, and two, if they had been able to hear that issue, that they would have won on the merits. So this can be a very difficult thing to do, and it's not something that a tenant should rely on to get more time. Okay, wow, I finished with a minute to spare. I'm very pleased with myself. I see a lot of questions. So I'm going to try and get through those really quick. But we'll have a little bit of time at the end as well. I think, all right, so one of the ones that I want to talk about really quick, just because this does get slightly complicated, is that Anonymous is asking about attorneys' fees that are being assessed after the fact. So this is a fun one in that the statute limits the amount of attorney's fees that a landlord can add on to the redemption amount. But a lot of leases will have language that says that the landlord can basically turn their attorneys or their legal fees over to the tenant to pay as well. And so there's a tension there, right? And so what has really been decided is that the attorney's fees, attorneys at this point cost more than $5 generally. And so if that clause is in the lease, the landlord can pass those costs on to the tenant, but they can't, it's not part of a redemption amount, so they can't like evict the tenant over them, is really what it boils down to. It is a debt that the tenant potentially owes, but how the landlord actually goes about collecting that is going to be most likely through like a collection agency or through a conciliation court claim. It's not going to be through eviction action. Okay, Steve is up next. So I apologize, folks. Like I said, we've got a lot of information coming in here. I will try and get to those questions that are still here at the end of our session today, but I want to make sure to be respectful of Steve's time and let him get into expungements. Thank you, Steve.
Thank you, Rachel. Is my sound on okay?
Yep, I can hear you just fine.
Great, great. Okay, Rachel has described the eviction action. One thing that an eviction action causes is a court record because the landlord files the eviction in court. It's a public record and it's a really bad thing for a tenant to have an eviction on the record. When a tenant applies for an apartment or a rental, there's a record check. And it may be done by the landlord, most likely by a screener hired by the landlord, but they will find that eviction. They'll find it on micro. If the eviction is expunged, then if they know a file number, it'll say no cases match this number. And if they search by name, they'll learn all about all the parking tickets the tenant has ever had in their life, but they will not know about the eviction. It'll simply not be there. And that really has to be a primary consideration in the eviction process. It isn't just for the tenant, it isn't just making the eviction process less onerous, it's also getting it off the record. Now, Rachel alluded to a procedure which is getting far more common. Most cases settle, a lot of cases settle. And the settlement may involve a payment plan, or it may involve a vacate date, or it may involve both. But the settlement presumes future activities on the part of the tenant, either vacating or paying the payments on the payment plan. When a settlement is being negotiated, the tenant or the attorney for the tenant should also negotiate the terms of expungement. That if the tenant fulfills the settlement and does whatever they're supposed to do, the court normally will not hear about it. So someone has to inform the court that the tenant fulfilled the settlement. And that's done by the filing of an affidavit of compliance. It could be filed by the tenant, by the landlord, or either one. But it notifies the court that the tenant has complied. They've made all their payments, they have vacated, and if the settlement requires, maybe they've done both. Okay. That affidavit of compliance should also state that the parties, both of them, landlord and tenant, agree to expungement, immediate expungement. And that's part of the deal. That was submitted to the court, and the court, of course, must accept the settlement. So the court has already, in a sense, granted the expungement on the presumption that the tenant fulfills it and that the court is properly notified that fulfillment has occurred. It's part of the deal. Now, immediate means that there doesn't have to be a motion. It just the court orders the expungement. And expungement can only be done by the court. The parties technically cannot agree to expunge, but they can tell the court that they agree that it should be expunged, and then the judge will follow that up with an expungement. Once the court signs an order, often prepared by the landlord, expunging the action, it should be done immediately. Sometimes in some counties, it takes a couple of weeks. But that is becoming the most common means of getting an eviction off a tenant's record. And there's no necessity of a motion. But the important thing is that the parties can agree that the expungement should be granted, but only a court order can expunge an eviction. Now, statutory expungements, the next slide shows, are two types. One is statutory, simply because it's authorized by a statute, and the other is discretionary. Statutory, the statute is 484.014 subdivision 2. That's the statute. It's not in 504B. It's in a chapter under the judiciary, but it's the legislature authorized statutory expungements, and that occurs when the original case had no basis in law or fact. The "and" that's in that sentence is a typo, which unfortunately I didn't catch. But it's when the original case, when filed, had no basis in law or in fact. Some examples, the plaintiff is the property management company and has no right to possession. The tenant has moved prior to the eviction being filed and does not have possession at the time of the filing. There may be service issues, particularly if they've moved, because often they not only have moved, but they never got served because they weren't living at the premises at the time the eviction was filed, or the tenant prevailed on the merits. So an example, which is shown on the next slide, is kind of an easy case. And this is an excerpt from the motion. Defendant asked the court for immediate expungement. And that's what the statute, how the statute reads. The court may order expungement upon filing that, and then a quote, the plaintiff's case is sufficiently without a basis in law or fact. And then it follows with language that states expungement is clearly in the interest of justice, and those interests are not outweighed by the public's interest in knowing about the fact. Now, keep in mind that the verb there is may, not shall. The legislature is not directing or mandating the court to expunge. Instead, they are saying that you, the judges, may order expungement. If you find that the case had no basis in law or fact, and that the expungement is clearly in the interest of justice, and these interests are not outweighed by the public's interest in knowing about the record, which begs the question, if an expungement has no basis in law or fact, how could the public have any interest in knowing about the record? And that kind of argument kind of infers that you're saying, Judge, you have to do it. It's mandated. But if it said shall, then the statute would be unconstitutional. because it would violate the separation of powers. And that holding occurred in Sella Investments versus JP. It just happened April 21, 2025. Statutory mandates are not permitted. The legislature cannot tell the court what to do with its records. So the use of the word may, although it seems to be inconsistent with the idea that there's no basis in law or fact, actually saves the statute. The next slide, yeah, this one is an example of an excerpt from a motion. I was a tenant. Landlord filed an eviction. A hearing was scheduled for the future. I told the landlord that I paid the rent. The landlord checked and saw that I had paid the rent on time. The landlord files a notice of dismissal and the court cancels the hearing. That's an eviction that had no basis in law or fact, but here's a problem. The eviction is still on the record. Generally speaking, the landlord prepares the motion to dismiss and requests that the hearing be canceled, and the court grants it. But the eviction is still on the person's record, even though the statutes would seem to almost require its expungement. And so the tenant, in this case, in the motion to expunge, cites the statute, points out the eviction had no basis in law or fact, and the public has no interest in knowing about this eviction. Essentially what I'm saying is, although mandatory expungements by the legislature are unconstitutional, this statute, it can always be argued that the court really must grant the expungement, because how could the public have any interest in knowing about the eviction if it had no basis in law or fact? Okay, next slide. This is the other type of expungement, discretionary expungements. There's no statute. There is no statute. The court is relies on the court's inherent authority to manage and dispose of their court files. The statute actually that's cited in that slide actually refers to the statutory expungement. There is no statute on discretionary expungement. Next slide explains the balancing that would be required in a discretionary expungement. So let's go to the next slide. This is a quote from a case. The court shall expunge the eviction within its inherent authority because expungement is necessary to the performance of judicial function of effecting justice, whatever that means. The burden on the court in issuing expungement is minimal. It's always minimal. It's always minimal. And the benefits of expungement to me are equal or greater than any disadvantage from the public, from the elimination of the record and any burden on the court. Very similar to the same standard used in statutory expungement, but there's a case that actually contains that language, the HRA of Duluth versus Young. Okay, next slide. Mandatory, well, let me say this first. What's different about mandatory and what's different from statutory expungements to inherent expungements is this. statutory expungements focus on the eviction action itself. What's alleged has to have a basis in both law and fact. Discretionary expungements can concentrate on the position of the tenant. Here's an example. My lease runs out on July 31, 2025. I am responsible for housing my 3 children, ages 10, 7, and 3. If this eviction is on my record, it will be impossible to obtain suitable housing for me and my children. I've applied 10 times and been turned down because of this expungement. In other words, in the discretionary expungements, you can stress both the details of the expungement itself and the position that the eviction record puts on the tenant. And for example, having children and being responsible for their housing is different than a person that is a household of one. Okay, let's go to mandatory expungements. In 2024, the court authorized a number of instances in which the court or the legislature essentially told the court when it had to, shall expunge a record. And the recent case that I've already mentioned, Sella versus JH, ruled that statute unconstitutional. Nevertheless, the factors that are in that mandatory expungement law, which incidentally is still on the books, it's just not valid, kind of feed into the no basis. For example, the statute said that the court must expunge if the tenant prevailed on the merits. Well, obviously, if they appealed on the merits, the statutory expungement would be relevant. Or the complaint is dismissed. Again, no basis in law or fact. And one could argue that if the parties agreed to the expungement, that also would be a valid basis. But the 3-year limit, that's out.
Yep.
I've prepared a template and I will give it to anybody that wants it, a template for a motion to expunge along with directions to the client.
Thank you very
Thank you,
much, Steve.
Rachel.
Thank you, Steve. Yeah, Steve has done probably the most expungements out of anyone I know here in the office. So definitely an excellent resource. I saw there was one question here quick. I want to make sure we're a couple minutes over. So I want to make sure Tim has time to get through what he needs to get through. But I also was wondering, how long does an expungement stay on for an eviction? If an eviction is expunged, it is gone. It's like you've burned the record. It no longer exists. It's no longer findable. So if an eviction is expunged, it's permanent. So that's that answer. All right, Tim, are you here with me? I know I saw you coming, flickering in and out.
I'm here. You got to give me the
Oh, I'm
camera.
sorry. I turned your camera off before. I'm sorry.
That's okay. Public service.
We'll. All right, there we
I
go.
can get started. Thank you, Rachel, and Steve for going through this. Evictions. I am going to be talking to you about some post-tenancy issues that I'm pretty passionate about. And you can go to the next slide. It's security deposits. And this is governed by Minnesota Statute 504B.178. When you end a tenancy, you've already paid this. If you have, if your lease has a deposit, you have already paid this. So this is technically your money, as long as you don't have any unpaid rent and haven't done any damage to the property in a willful, malicious, or irresponsible manner. And we'll get to that a little bit later. But to start off, you as a tenant need to give a forwarding address to the landlord in order to get the security deposit or the disposition letter. This doesn't have to be the address that you are moving to. It needs to be just a physical address that you can, you know, it could be your work, it could be your parents, it could be your sibling. It just needs to be given to the landlord in a way that you can show that the landlord got it. Because then that starts well, as the end of your tenancy. And this could be, you end your tenancy before the written date on the lease, you come to an agreement. Whenever the tenancy ends and you've turned in your keys and you no longer live at that apartment, the landlord has 3 weeks from the termination of the tenancy to send you the full deposit or the disposition letter. And this is a 21 days. It takes 21 days to for them to postmark it. It doesn't mean that it has to be delivered to you by 21 days. So sometimes people say, well, it's been 23 days. And I tell people, well, just wait for another, 2 or 3 days to see if you actually get it, and then see what the actual postmark date is, or what landlord actually dates the letter that they give you. If you want to go to the next slide, in addition to the deposit that you paid at the beginning of the leasing, those funds, there's a 1% interest per year that you've lived there. So if you paid $1,000, you get $10 of interest put into that gets turned back to you. Now, something interesting that I've encountered a handful of times is somebody's been living at an apartment for 15 years or 20 years, a long time tenant, and they moved out. Do you get interest for those full 20 years? You should probably call us, because we have or we can track down what the interest was for the years that you lived there. It's gone up and down over the years. It's currently 1%, but you're entitled to that interest to be returned to you on top of the security deposit that you paid into. Something that does happen is if there's a transfer, it's like the landlord pay or sells the apartment or house that you're living in. The deposit has to be either returned to you or transferred to the new owner. The old owner can't just take your deposit and leave with it. It's part of the sale. It gets transferred over. 504B.178 explicitly says how it's supposed to be transferred, and that should, as long as you have the proof of when you actually first paid it, that should be sufficient to show that you paid, and that the new owner needs to when you go to move out, the new owner needs to make you whole from that amount that you originally paid. Sometimes tenants say, well, we're going to, I've already paid in a month's rent, so I'm just not going to pay my last month and let this the security deposit pay for that. I would caution people about doing that, because the landlord has no obligation to use the security deposit as last month's rent, and you could get into a situation where you're facing an eviction and they're able to withhold the security deposit as well. What I would say is it's not on this list, but 504B.206, which I was talked about earlier in the webinar, that is the only time that you forfeit your security deposit if there is no unpaid rent or damage that's done willfully, maliciously, or irresponsibly. That just you forfeit that, and it's not a penalty, but it helps the landlord recoup some losses if you have to use that VAWA exception to move out earlier than your lease states. So if we go to the next slide, what normally happens, or this is just this is a sample of what happens. You paid in $1,000 deposit, you get your interest, your $10 interest. If the landlord does not return the security deposit or give you the letter saying why they kept the security deposit within 21 days, 504B.178 allows you to multiply the the um, the deposit by 2. That's a penalty for missing the 21-day rule. That's a pretty substantial penalty for, somebody that's moving out. In addition to the multiplied by 2 penalty, if they withheld it, you can ask for the $500 punitive damage if they withheld if they said that they charged you $700 to clean your kitchen. And it wasn't, there's no stains or whatever. It's just a general cleaning charge. The landlord has the burden in order to prove that what they charged is actually what like a reasonable amount, or why they had to charge the amount that they did. I've seen hazmat uh charges from landlords. That's not unless the landlord is, a licensed hazmat tech or runs a hazmat cleaning company. That's probably not going to be the correct type of withholding. There you can go through and see what was withheld and dispute that and put the burden on the landlord to show that that is actually um, what you owe. And if we go into the next slide, or yeah, so I guess the whole total is you only paid in 1,000 if the landlord doesn't abide by the 21-day rule and they wrongfully withhold, you get an extra $1,500 on top of that deposit. And now what deductions from deposits, what can they actually hold the money back for? It's damage that goes above ordinary wear and tear. 504B.178 explicitly says that it's willful, malicious, or irresponsible damage. So if you left your window open in the middle of the winter and the pipes froze and there's a bunch of damage that was done, that's probably going to be taken out of your security deposit. If you have unpaid rent that you move out and there's still unpaid rent there, they can also landlord can also withhold the deposit for that. They still have to send you the notice, but it is that is something that they can withhold for. The landlord here it says the landlord does not have to paint or change carpet between the tenants. That means there's no it doesn't say anywhere in 504B.178 that you have to pay for new carpets when you move out. That's unless there's holes in it or you've done something willfully, maliciously, or responsibly to the carpet, that you don't have to pay for new carpet or carpet cleaning charges that are just standard in the lease. If the lease says, when you move out, there's going to be a $300 cleaning charge, and that's in the lease to begin with. You can still sign the lease, just know, and you can ask the landlord, hey, this isn't legal. I would just probably sign the lease and see what actually happens down the line. You can tell the landlord, hey, like this isn't legal. There's non-waivable rights here in 504B.178 that protect me. But it has to be something beyond ordinary wear and tear. What I in closing up, and I'm going through this kind of fast. It's important. Actions when you move out. Let's just say you've had a really rough time with this landlord for the last 6 months, and you're set to move out, and you're afraid now you can't. You're wondering, oh well, I've lived in a house or an apartment that it wasn't up to the levels of habitability that 504B.161 affords me, or you've had issues throughout that the landlord just didn't fix, and now that you're moving out, you can't bring a rent escrow action because you're going to be moving out, and the rent escrow action is just to remediate the issues that you're having with the property. But what I tell people is wait the 21 days after the tenancy is ended, and then see what they do with the security deposit. And then because you're going to package everything up and bring it to small claims court yourself. So if you move out and you and the landlord haven't been seeing eye to eye, and you're worried that they're going to keep the deposit, there's not much that you can do to get paid before the 21 days. You wait the 21 days, you see how the landlord returns it, or if they even send you the letter, and then you can package in other claims that you have with the 178 claim. It's easier to do that. Your statute of limitations should be fine because you're going to be acting within a month after the tenancy ends, probably. But it's a little bit easier to file a claim that includes, 504B.161 claims as well as the 178 claims, or if you have privacy violations that happen throughout there. This action at the end to recover your damages given to you by 178 should all be packaged together in small claims court. And we're going to come back to 504B.178 here because the move out and move in inspection 504B.182 is mentioned in 504B.178. 504B.182 it allows, or it mandates, that the landlord needs to offer a move-in inspection and a move-out inspection. It's a new law, and it hasn't gone up to the Court of Appeals about that I'm aware of. So the language in 182 for the initial inspection says that within 14 days of the tenant occupying the unit, the landlord must notify the tenant of their option to request an initial inspection. And that's where you go through with the landlord and you say, hey, this is wrong here. It had been done in the past. Landlords had given, the move-in inspection that you go do it by yourself and then you turn back in the form. Now 182 requires that within that 14 days, the landlord needs to let you know that you have the right to an initial inspection. Same thing for the move out inspection. There's at a reasonable time, but no earlier than 5 days before the termination or the end of the lease, the tenant plans to vacate the unit, or the day that the tenant plans to vacate the unit, the landlord shall, upon the request of the tenant, make a move out inspection of the premises. So this gives the timing of this happening like 5 days before, in theory, is so the landlord goes through your house and says, yeah, this needs to be cleaned more, or this looks like it's broken, or it allows the tenant to fix those issues, or at least be not surprised about what the landlord is going to be charging. And that it doesn't mean that at this inspection you're going to argue. Like, the landlord might just say this is above ordinary wear and tear. You two could both disagree about it. It doesn't mean that at the inspection the issue is going to get resolved. It just so you're not surprised by that. Now the teeth to 504B.182 is in 504B.178 subdivision 4. I'm sorry, subdivision 4 part 4 under damages. If the landlord fails to give you a move in or move out inspection, whatever they actually withhold from the deposit, you can ask for that money back in addition to that same sum. So it effectively doubles the amount that has been withheld from you. I would say it's a very useful tool, and something that I think is positive because it allows, it starts the discourse between landlord and tenant. What I would say, though, before we move on from security deposits, if you're in a situation that the landlord is alleging that you owe a lot of money, like let's say they're saying that you're responsible for $10,000, $15,000, $20,000 worth of construction, that is a prime time to sue in small claims court under 178, because if you don't sue under 178, then the landlords are able to send that to collections. And when that happens, it's a big mess, because you have to dispute it with the credit reporting agency. And without having a court order saying this is actually what you owe, and if you're being told that you owe $15,000, hopefully it's a lot less than that. It's only like his landlord has a liability to upkeep the apartment, but you want to have a third party judiciary official actually order what you owe, because then you can show that order to the credit reporting agency or the collections agency and tell them that the debt is obsolete. We'll go on to the next slide. I'm kind of going long here. Another aspect of the post tenancy is if you just leave property there. The general rule is that the landlord must store the property for 28 days on or off the premises, and the tenant can recover property by giving the landlord 24 written hour or an hour 24-hour written demand, or 48 if it's stored off site. There are some penalties that the landlord can incur here if they don't abide by the written requests to get into the property or get it back. I think they're up to $1,000 per violation. That's a 504B.271. The landlord, after that 28 days, the landlord can sell or dispose of and keep the amount of, or the fund, an appropriate amount from the funds of a sale, or send to collections for the storage of that property. The same thing holds true for following an eviction. The landlord, if you get evicted and your stuff gets put out, they just can't throw it away. They have to store the property probably in a bonded warehouse, and that you can let upon written request where it is and when you can pick it up. The problem, or not the problem with that, but the storage place and the landlord can also have a lien against you for the storage costs. So if we want to move on to the next slide, that was a pretty quick overview of abandoned property. Now we get into lay advocates. Sometimes.
I'm going to pause you real quick, just because we've
Okay.
got two questions about the security deposits and all of that stuff.
Okay.
And so if you lived in a place for many years, do you still get your deposit back?
Yes. Yep. And we went over that, and you get interest
Yep.
for it. And if you've lived there for a very long time, give us a call because we know what the interest rates were for those years.
Yeah, it has fluctuated a bit. And so does a lack of a move-in inspection prevent a landlord from charging damages
No,
when a tenant moves out? Yeah.
sorry, I didn't mean to
No,
cut you
you're
off
okay.
there. Yeah, no, it does not. It does afford you that extra penalty for what they do withhold. If so, it doesn't guarantee that they send it back. That if they don't, you get whatever is withheld times 2. So I think that answers the question.
Yep.
Yeah, so no problem. And now we'll get into lay advocates. The small claims court, I have really bad lighting, I just noticed. The small claims court is designed for the people to use, not lawyers. Small claims judges don't really like it when lawyers come in, honestly. That being said, 481.02 subdivision 313, the very, very buried, I guess, in statutes, is a permission for a layperson to represent people either in, in housing court matters. The problem is that they can't charge for their fees. They can't pretend to be a lawyer, can't appear in jury trial or appellate court. Really, there's no incentive beyond helping somebody that can't speak for themselves, or that are shy, I guess. But you can't charge for your services. It's pretty limited as far as what you can do. This case right here, Nicolette Restoration, says that you can't a layperson can't represent a landlord in conciliation courts. Casts a little bit of doubt because the landlord should hire an attorney. that yeah, I'm sorry, I lost my train of thought there. Basically you can go to the next slide, Rachel. This is the list of what a layperson could do. So if this is basically saying if you want to go, if you want to ask your friend who isn't a lawyer to represent you in a housing court matter, these are the things that they can do. They can write for you. They can prepare a motion for you. They can be present in the court hearing. They can talk to the housing counter for you. They just can't charge you for any of these things that they do for you. And then we'll go to the next slide. And then the things these are the on the fence issues. Can a layperson address the court in the court hearing? It most likely you're going to have to ask the judge's permission. Signing a settlement letter, I would really caution anybody that is signing a settlement letter as a lay representative. I just wouldn't do it, honestly. Don't sign where you're helping your friend out. Honestly, like, let them sign it. You can, according to the law, you can counsel them and tell them what you feel the law is. But I would really guard against putting your name where the person in the place where the person that you're trying to help is. And so we just went through that pretty quick because I ran long on talking about security deposits. But if anybody has any questions, please
Yeah.
put them in.
Yeah, we've got about 3 minutes left. Well, 2 minutes left now. So first off, I want to thank you, Tim, for going through all of that. I know it's a lot of information, especially some kind of disparate statutes there. So like I said before, for everybody, we have applied for CLE credits for this action, or excuse me, for this presentation today. We've applied for 4 standard CLE credits. We have not gotten approval yet, but I do have a code here, so you can hold on to this, and we will, again, I'll email everybody, or someone will email everybody with this information once it's approved, but the code is 529322. If you have no idea, and you're on this and you have no idea what a CLE credit is, good for you. It means that you don't have a legal obligation to do these sorts of, register these sorts of things. But again, that code 529322. And I'm sorry if we did not get to any of your questions. There's a lot of information here. If you have a specific question and you are a tenant, feel free to give us a call. If you're an attorney, you've got, just want some consulting, feel free to email us as well. But thank you very much, everyone, for joining us today, and have a wonderful rest of your day. Take care now, and goodbye.